Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome to our next episode here of the Casey Anthony trial. And I know it's been a little while since our last episode, but don't worry. As always, we will have a recap from last time to get everybody all up to speed and remind us what was going on. We're in the defense's case in chief right now. And they have been presenting their expert witnesses. And today that will continue. And there's lots of drama that we will have in store for us in this episode today with these defense expert witnesses. Those of you guys who love drama in the courtroom, you will definitely be in for a treat. So, but first, what I wanted to do is show you guys something here. So give me just 1 second. Let me pull this up. So here's what this is.
I was doing the case.
So let me just explain what this is. So this is Vinnie Politan on Courtroom Confidential with Josh Ritter, which is awesome. This episode was awesome. If you guys haven't seen it, definitely recommend checking it out. Vinnie's background and his life story is so interesting and not at all what I expected. This is a really, really great episode. And of course, Josh Ritter's awesome too. But what's funny is this is a really short clip, but this is where he mentions the Casey Anthony trial and Nancy Grace. And I think you guys will find this interesting, what he says about this. So
when I was doing the Casey Anthony trial on my little 5 o'clock show, right? My little 5 o'clock show, which was, I'm trying to remember the name of it because I had 2 shows then. I think it was.
Hold on, let me pause real quick. So look at Vinnie as just a little baby spring chicken Vinnie there.
Clock show, which was, I'm trying to remember the name of it because I had 2 shows then. I think it was, I don't even know the name of it. HLN story, whatever it was. It didn't have my name in it, so that made me a little angry, but it was a show. I beat Glenn Beck on Fox by like 1 million viewers.
That's incredible.
It's crazy. Like these numbers were crazy, like crazy. But what you had to understand and figure out how to do was to take the big moments in the big trials and sustain the rest of the time as well and be able to create interest in the other cases. And the mistake that was made at the old court TV and the lessons that I learned that I made sure we didn't make the same mistakes at the new court TV was that we would never look to, all right, what happens next? What happens next? Like at the old court TV and at HLN, we would get caught in the moment of the big trial. Casey Anthony, Jodi Arias, here we are. Look at us. Wow. And we're just all in on that story. But what are we doing next?
Right.
What are we doing next?
Because this one's going to end.
It's going to, we know every trial ends, usually with a verdict, right?
Right.
And you have to understand the ebbs and flows of big cases and then other ones. So how do you do that? You've got to make the others, because it was almost like arbitrary how some cases would just get huge for whatever reason. Casey Anthony, it was Nancy Grace, period. Full stop. She built that story. She absolutely did. And I always remembered that because that's when Nancy was on HLN. She was on in prime time at night and she wasn't covering a trial. She was covering a story.
So I'm pausing real quick to say that was what was so key for me. She wasn't covering a trial. She was covering a story. And boy, is that true, right? Because the story that she tells is not actually factual at all. It's a story. It's a story, right? And I wanted to also note, in addition, we have watched every single day of this trial, and we're on day 20 right now, and it shows the gallery. She's not in that gallery. She's not in the gallery, So I just thought that was interesting to hear his comment on that, that of what he's saying And I understand what he's saying, right? That there's a story behind it. But of course, as we who actually watch this trial know, in her case, that story is not accurate. And I think that that's not a good thing. So
it started as the search for a little girl, then all the drama with the parents, and there was something happening every day, and it was a snowball going down the mountain.
There it is, a snowball going down the mountain, guys. So snowball of misinformation, I would say. So so that's what I wanted to show you guys first. But again, do check out that episode's really interesting of Courtroom Confidential, Vinnie on there. He's had a lot of different guests on, including Joel from SES. And it's really great because he just kind of interviews them. But Vinnie's story is really, really interesting. So definitely recommend that. So now let me pull this up. We will do our recap from last time. So here we go. So this is from episode 19.
It's a house.
Most of my casework comes from law enforcement. I'm also a reserve deputy sheriff at the Seward County Sheriff's Office.
Yes, the bugs. Oh my God, stop it. Objection bolstering, stop it. Stop. So you guys, does this feel like forever ago? Those of you guys who were here, I know you were here, Candace. This was such a funny day. This episode was wild, wasn't it? With the bugs. And if you guys remember too, I'm sure it'll be in this recap, but now because it does feel like a long time ago. It was before the holidays and everything. But the part with the jump scare with the pig picture and the redacted version, I'm sure I'll include that in. Stop it.
How many times have you consulted as a forensic entomologist
Ashton was just
for law enforcement?
For law enforcement, I believe.
What?
Yes, sir. I've done a number of invited presentations to a number of different agencies. I've traveled outside the country to do that. I also taught a class, currently still teach a class at the University of Nebraska. I'm an adjunct professor there, and I teach a class on forensic entomology. I also lecture on it extensively in my own classes. All
right, let's play a game. How long do you think before the next objection? How do we want to say how many questions? How do we want to do this? We can make this a game for this witness.
You have to submit publications. You have to take an exam, which takes about 12 hours. It's a lab practical, a written exam, and then a case study exam. At the time that I joined, as I said, I was the second member to actually join.
Excuse me. Objection, Bolton. Can we push that?
There it is.
You were talking about being a...
So let's come up with a system. I agree. We need to do that because this is going to be really funny for this witness. So maybe the easier way to do it would be counting the questions, because usually, with an expert witness, right? Sometimes the responses are really lengthy, and there's fewer questions. Like with a lay witness, it could be the opposite, but here, usually the questions are fewer. So maybe to count the number of questions from Mr. Baez would be the easier way.
Once that transformation is complete, the adult fly is going to emerge out of this, okay? The ends pop open, they wiggle their way out. They're soft and squishy, just like a butterfly is when it comes out of a cocoon. They take some time to harden their exoskeleton, to flex out their wings and let them dry, and then they fly away and do their fly business.
Their fly business. Yes, sir. Yes, they do their fly business. That reminds me so much of chicken business. Like Alex Murdoch saying on the witness stand there, what did he say? It goes about its chicken life or whatever. It's like when he's talking about how the chickens usually come back. He's like, yeah, and it just goes about its chicken. He might even say chicken business, or they do what chickens do, or they have their chicken life or something like that. Anyway, shout out to the fly business.
So by crawling away from a food source, say, in this case, a decomposing body, they get away from it, hoping, I don't know if that may be humanizing them too much. They crawl away from it.
Y'all know he thinks of bugs as humans, right? I mean, that's obvious. They're like his friends.
To prevent other insects, other animals from coming along and eating them. Because if they can hide away from the food source,
that makes sense.
The chances of something coming along, finding them and eating them is reduced.
That makes sense. And again, that was never explained at all by Dr. Haskell, but that makes sense. I remember him saying something about an energetic phase, and that's literally all I caught from Dr. Haskell. But that makes sense. He's like, they don't want to die by getting eaten, so they have to go away. The way that they teamwork approach. Watch the teamwork. Watch the teamwork. Teamwork. Very good. This just reminds me of something.
However, sorry, team approach, I guess.
Love it. Teamwork is dream work.
Let's talk about this. I'd like for you to tell the ladies and gentlemen of the jury what we're looking at and a little bit of background as to what you were trying to do here.
Okay. Obviously, this is a car. Place them in the trunk of the vehicle, close the trunk. There were no flies on the pig at the time that I closed the trunk, and then watched, observed for any signs of insect colonization associated with trying to access or accessing physically the pig remains in the trunk of the vehicle. Rain greatly suppresses insect activity. You don't see any insects flying around in hard rains, because when you think about it, if you're the size of an insect, I mean, that's like a 55-gallon bucket.
That would be terrifying. Just to think about the life of a fly if you've got rain. Can you imagine? Where do they hide out? I wonder.
Barrels of water coming down. You don't want to be out and about in that kind of condition.
Sorry, hold on. Do they get little umbrellas so that they can go about their fly business? I'm just picturing a fly with like a little umbrella, like a decorative umbrella with like hearts on it, or little unicorns. Like I have a unicorn umbrella, like going about their fly business, like a little tuxedo and like a fly umbrella and like a briefcase. Okay. So I'm ready to go with my pig redaction. So you all are probably going to laugh because it wasn't easy to redact this. So I had to redact it by obscuring it with like video effects. We'll see it in a second. It's pretty funny, but it does the job.
These white spots on here that you can see are maggots that have fed on this pig. These maggots are actively crawling away from the pig. As I explained earlier, they're getting away from that food source, and they're looking for a place to pupate.
Mr. Ashton?
Have we finished eliciting the opinion from the witness? Because it seemed like we stopped. Obviously, he's not qualified to talk about phenolphthalein tests. We've already heard from an experienced serologist about that. So clearly he's not qualified to testify, and that's not in his deposition. But is there any other opinion counsel's going to elicit? Because, I'm sorry, I'll wait. Counsel's busy texting. So. Is there another opinion?
I don't know how many times, I'm not going to say this ever again. I do not want to hear editorial comments. Let's
I love it when Judge Belvin gets sassy.
stick to the facts. I care less what Mr. Baez may be doing or not doing. All I'm concerned with at this time
I love it when he gets mad.
Is the proffer and whether or not what's in his report versus his deposition is a violation of this court's order.
His face.
I do not care if Mr. Baez is standing on his head,
Amazing.
standing on one leg.
I just paused. Like, oh my God, this is so funny. Look at his face.
So, folks, please, let's just
Wow.
stick with the facts and be
Oh my gosh,
professional.
we're zooming in. You know what's really funny? We did this with the spring chicken in the Ezra trial as well. The spring chicken prance, we called it. Look, he's definitely got a prance as well. Love it. Love it.
In cases that I've worked with, in both from a simple association with mortuary services, removing bodies, as well as in casework that I've conducted, I've never seen a case or never known of a case where a carpet was cleaned. Those carpets are removed and destroyed. In fact, a case that I did in Nebraska, a body decomposed.
I knew it. I knew it.
Sustain.
Give us some examples of what you're talking about.
Relevance, another example.
Oh my God. Okay, we got 3 and then 0 on that one.
Can you give us some relevant examples?
Sustain. Rephrase your question.
Yes, sir. Can you give us some relevant examples?
Well, Judge, I don't believe that was the witness.
Oh my God.
I think that's
Sustain.
Can you give us a relevant example that would help you explain to the jury what you're trying to tell us about this
I
specifically?
think that's kind of the same question.
Oh my God.
Same question. You can ask the witness whether or not he has an example dealing with a trunk stain in the trunk of a car.
Getting it all set up on the easel. Excellent.
Can you see that as well, Mr. Ashton?
Could we just project the
Oh.
image on the screen so we can
No.
look at it? Is there an evidence?
I think
Why?
we may be bouncing back and forth. It might be a little easier.
Why?
Okay, I'm gonna have to stand over here. That's
okay.
so you're gonna have to stand back.
Fucking hell.
Is the microphone? Okay. Can everyone hear me okay?
Although I will say, at least he's lounge lizarding, kind of. He's not really doing it correctly, but he's like trying.
An item. I'm going to refer to States 128, which will be the photograph on the left.
Yeah, he's not really lounge lizarding. He's just kind of like leaning. So.
Or they were able to recover, I guess, maggot or insect activity off of this dry garbage.
Let me object for a moment. I'm not sure the testimony indicated they took it off
Let me object for a moment.
the garbage in that condition.
Is there anything inconsistent with what you found in
Mr.
the
Ashton, you
trash
stupid.
and what you found in the entire trunk that would lead you to conclude this is anything, or this entomological evidence is anything but the result of a bag of trash in the trunk of a car for 2 to 3 weeks?
There you go.
I would expect to find the same thing in a bag of trash, in the car trunk, in the back of somebody's house, virtually anywhere. It's
Yep.
a bag of trash with trash feeding insects in it. There's nothing remarkable about that.
Excellent. There it is. There it is. I mean, and you know what? Again, this just makes common sense, but there it is from the expert. There were 29 objections during direct examination. And so the average number of, I just did the math with a calculator, the average number of questions that were asked before an objection was 2.39. By the way, I just calculated the mean. The median. I just calculated the median. The median number of questions would be 2 questions. By the way, amazing.
There is a definite window where they lose any attraction to the remains as a food resource because they're looking at it as a resource for their offspring. Just like any other parent, they want their kids to do well.
Oh
so
my
they're
God.
not going to be attracted.
How cute is that, though? They want their kids to do well, just like any other parent. Oh my God.
They're not going to colonize remains that are not going to be favorable to their offspring.
You showed us the chart.
McDonald's Christmas is on the
Oh, this is one around Fence Exhibit AW.
boy. Oh God. Sorry, guys. Sorry. I did not know that happened again. You guys, here we go. Y'all ready?
You guys remember that?
There it is. There's the tie. That is the tie. That is Mr. Ashton's tie. I still have no idea what is on the tie, but that's the tie. So now we know. There it is. Found it. Woo! Oh God. Oh God. Oh look, people.
I have never had occasion to work on a case with a body in a trunk.
Never.
No, sir.
So all of your opinions you've given us here today about what you would expect to see from a body decomposing in a trunk come from this one experiment. Is that correct?
No, that is not correct.
Where else does it come from?
There are a number of sources in the literature, specifically case studies, that deal with bodies recovered from vehicle trunks.
Why didn't you wrap your pigs in a blanket?
Oh my God.
I promised I'd say that, Judge. But seriously, why didn't
It's like he's trying to make a joke, but he's yelling it. I don't even know. This witness is a good sport.
you wrap your pigs in a blanket?
Thank you for saying that.
That's okay. We needed it right now. Okay, the trunk would have looked like with Caylee's body in it because she was wrapped in a blanket.
I'm sorry for the scream. I can't with that picture. I will, y'all, I'm sorry for this. You heard my scream. That's my reaction. I will edit this and blur it out, although it's going to be tough. I'm going to have to try to do it with my eyes squinted because I can't look at that. The camera is like jumping around and now it's like randomly showing that stupid pig picture, which I thought he took it down. Ugh.
So were any of the studies that you did look at involve bodies wrapped in plastic?
So as y'all can see, I was able to redact that on the after the fact, the stupid pig picture. By the way, Candace letting us know that as far as the Los Angeles fires, Candace has posted a link in the Discord with mutual aid organizations that need donations. Thank you for that, Candace. Seems like as we just got an update here from Candace, who lives in California, that the fire is making its way towards the UCLA campus. So it's insane, really. And hopefully any of you other squirrels who are in California, hope you guys are all safe. And I hope that they can put an end to that soon.
Bags in trunks.
Yes.
How many?
One. It was a case study of a homicide. I don't think they wanted to replicate it.
I'm sorry, what was that? What was that relevant to what I just said?
Oh, fuck. Oh, fuck. Oh, fuck.
Okay, we'll move on. We'll move on. So one case study.
Yes,
One
sir.
case study. And tell us the circumstances.
Wow.
That was a body recovered in Europe.
So
Okay. Well, he's taking the pig picture down, so that's
only one of them dealing with the trash bag and trunk. Is that what?
The one case study. Yes.
Why couldn't a trash bag which is sealed and wrapped keep bugs out? Isn't that why we buy them from the store to
this
keep the
part.
bugs out of our trash?
got to be kidding me. To keep the bugs out of our trash? Wait. Okay, first of all, first, why do you guys buy trash bags that have closings on it? Why? What is happening right now? I don't even understand. I mean, if anything, you want the bugs to stay in the trash, right? He's like, I want to keep the bugs out of my trash and instead in my home living environment. What is happening? He's like, I want to protect my trash from the bugs so they can be out. Like, what? I don't.
Did you ever experiment with the effects of chloroform on attracting
For
flies?
fuck's sake.
No, sir.
Did you,
Overall,
did you, in your experiment, put chloroform in any of the trunks with the pigs to see how that affected the early colonizers?
This is so
Beyond the
silly.
scope.
This is beyond.
No, sir, I did not.
We've now gone into fantasy land because I like the chloroform. The chloroform is fantasy in this case. It's just fantasy. And so now we've gone from pigs in a blanket to the chloroform. We're adding in, he's not in, Mr. Ashton has left reality.
I think what you're getting at, or what the way I'm hearing the question is a misconstruction of how those flies are attracted. The flies don't smell
Correct him.
the odor the same way you and I do.
Excellent.
The flies pick up on individual molecules of those sulfurous compounds that are emitted, and because of that, changing the content of the air. Okay, the chemicals that are floating around in the volatile gases in the airspace, you would have to replace every single one of those volatile sulfurous compounds that the flies are attracted to, one for one, essentially, to prevent their attractiveness. Does that get to what you're asking?
I think it does, but you will acknowledge that there are no studies on this.
I will acknowledge there are no studies on this specific
This
interaction.
is so,
Well, is there on others? Chloroform with other insects?
With chloroform specifically,
what is going on?
I don't know.
The paper towels that were found in the
What are we in? Victorian England? Like, chloroform, y'all. When I hear chloroform, literally, I think of like Victorian, like 1800s in like England. Like, no one's thought about it since up until this trial. Like, what? Like, I'm sorry. It's like, I can't even think of an example of something else that would be so obscure to ask, like, no one's done any study about this specific thing with this. Like what is happening?
Let me get your annotation out of the way.
Yeah,
Go ahead.
Okay. When you look at the close-up photos of the tops of those cans, several of them, somewhere 3, 4, maybe 5 of them, at least, were used as spittoons.
How can you know that from a photograph?
You can see the remnants of, let me back up. Everyone that I've ever met that has chewed tobacco and spit into a can that leaves them laying around, it looks exactly like those, in that there are bits of dried tobacco on the lid, and as well as the staining.
Do you have those photographs with you that you could show us that you're basing this on?
I have them on a computer, yes.
Well, actually, we have the actual items here. So maybe we should.
My God, are they going to pull out the spittoons? Oh my God, this is court is on another level. Talk about props, guys, in courtroom theater. Are they going to pull these out? Holy mackerel!
Just go through it.
Oh my God, they're pulling out the trash to look at it. He's hoping to prove, I guess, that I think he's only hoping to prove that the cans weren't used as spittoons so that he can get back to the plastic bottle, only to ask the question of, how did the flies smell it with the lid on? Which is a pointless question to begin with, because we all know they can smell it, because they can smell from over a mile away. Wow. Oh, he's going to struggle with the scissors. Okay, it's going to be a while. We're Look at this. Although it's fun watching him struggle. I'm dying. I'm dying. I'm dying.
Open up, see this one.
Accurate.
So this brownish substance on top of the tongue.
Yes, sir.
You know what's wild? Oh, wow. You know what's wild? Who knows if this was ever tested? This is bringing up a whole other issue. Again, this is all how, remember, this expert is an expert in forensic etymology. When I thought we'd already gone well beyond his scope, I didn't even know that this was coming, because now we're on to the substance on the top of the soda can.
Crazy.
And this has never been talked about. This has not come up yet in this trial. This is brand new territory. I have no idea if this was tested. This is insane. So if no one's tested that, like, what? I've never. What is happening?
May I first see the item?
This is crazy. This is crazy. This is crazy. What is happening?
So the only thing that may come close to being food is something that you may see in this salami package here. That's what you're talking about, right?
That is the salami package I'm talking about, yes.
11. All right, I'd like to pull it out. Let's take a look at it.
We're going to take a recess. Jury's been going since 1:30.
Oh my God.
We'll be in recess to 3:30.
Oh my God. Judge Belvin's had enough. I'm losing it. He's just, wow. It's like, what are we even doing? Like, what are we even doing? This has just gone off the rails.
And in my own findings, based on the evidence from the car's trunk, I find no reason to think that there ever was a body in there. And in fact, not only do I not find anything that says there was the evidence doesn't make sense.
Excellent.
Any way you look at it.
Yeah.
To say that there was a body in the trunk.
Yeah.
Everybody in the trunk. There you go.
If we work under those assumptions that the prosecution has laid out, then it actually argues against it.
Now, you were asked about Dr. Vass, and you were asked about
wait, hang on.
air samples.
What's happening to Mr. Ashton? Is he having a stroke? Hold on.
If we work under those assumptions that the prosecution has laid out, then it actually argues against it.
What's happening? Watch
Now,
guys.
you were asked about Dr. Vass, and
Oh my God.
you were asked about
Oh my God.
air samples. Have you ever heard of any case where
What is
air samples
happening?
were used in a
Oh,
forensic
boy.
setting?
Objection. Relevant expertise.
I did not personally test.
So I actually have clipped that separately. I'll show you guys. I've actually clipped that separately so we can watch it whenever we want to. And I've called it Mr. Ashton's schizophrenic moment. Let me show you guys. Here we go.
You were asked about Dr. Vass, and
Oh my God.
you were asked about
Oh my God.
air samples. Have you ever
God.
heard of any case where
What is
air
happening?
samples were used in a
Oh,
forensic
boy.
setting?
Objection. Relevant expertise.
It's funny on so many levels. It just, yeah.
The substance known to be adipocere to say that it is adipocere.
And other than adipocere,
I'm going to object and ask that the witness be allowed to complete his answer.
I'm sorry. I thought he was done.
Oh my God.
I've lost my train of thought. I don't know where I was
What a
going with that.
mess.
Would you like the court to read it back to you? I didn't think I was. I'm sorry. Would you like to read it back to you? Get you back on.
Yes, please, if you don't mind.
Okay. The attorneys approach the bench. All attorneys along with the court.
Yep.
Dr.
Saw that
Huntington,
coming.
So you would agree that it is within the realm of the forensic anthropologist to determine whether something is adipocere or not? Would you agree?
I think it is in many experts' realm, because if we go with that answer, then Dr. Vass is not an anthropologist, by my understanding.
I would
Oh,
move to strike
boy.
that answer as being
No.
unresponsive, as to jury to
Oh,
disregard.
God.
Jury's hereby instructed
y'all.
to disregard.
Y'all.
No further questions.
Wait. We're watching that again. You guys, Mr. Baez laughing because this was such a point of contention with I'm losing it. What a wonderful way to end this whatever we're on. The voir dire. I don't even remember what's happening anymore. This witness rocks. Seriously, he has hit all the points, the trash and the garbage, Dr. Vass not being an anthropologist because that was a whole thing. And the way that Mr. Ashton is so offended when it's his fault he brought in a shitty witness. Oh my God. Hold on. This is my favorite thing ever.
In many experts' realm, because if we go with that answer, then Dr. Vass is not an anthropologist by my understanding.
I would move to strike that answer as being unresponsive, ask the jury to disregard it.
You is hereby instructed to disregard.
Amazing.
Epic.
No further questions.
The way I think he's trying to hold on, let's watch this. The way that the cameraman watch this, guys. The way that the cameraman knows that because Mr. Baez is speaking words, and the cameraman already knows because Mr. Baez is speaking words, Mr. Ashton's gonna object. Watch. This is freaking hilarious.
Of things that could have been done to answer this question that we are all trying to answer for years later.
Objection. See if this phone correct.
Is this photo a good example of what human decomposition, or let me rephrase that. Is this photo a good example of what decompositional fluid would look like on a piece of carpet?
Yes, that's why I included it.
Okay. And is this photo, specifically State's Evidence 80, a good example of what what decompositional fluid looks like?
Wow. Powerful.
No, I don't consider it to be.
Powerful. Well done, Mr. Baez. Yeah. I couldn't even see a stain.
So when something gets wet, non-food items don't all of a sudden become food, do they?
Alchemy, sorcery.
Unless you're talking about dehydrated food, I don't believe they do.
I thought he was talking
So
about
whether it's wet or
magic,
dry,
like magic,
it's still not food,
like a wizard.
correct?
Not as I understand the definition of food.
Did you understand that you were to place in that report every opinion you had related to this case?
Beyond the scope.
It's impeachment, Judge, under, I believe Johnson is the case.
Well, Johnson doesn't stand for that.
Well, maybe I'm thinking of the wrong name, but
Oh my god.
Oh my God.
I would
Imaginary.
think that any forensic entomologist could look at that and come to the same conclusion that I did. I would expect them to.
Thank you, sir.
Yes.
Oh, for fuck's sake. I'm not even.
I'm sorry.
He doesn't deserve
I
it.
thought you told me a moment ago that you've never been asked to look at a stain and identify it before.
I'm sorry. I'm Mr. Ashton.
Was that a
Looking at a stain and determining whether it's decomposition or not. I thought you said you'd never been asked to do that before.
I've never been asked in a court of law, sir.
But when you just said to Mr. Baez, is this something that entomologists do all the time? Which is it?
Oh my God. Stop
Outside
it.
of a court of law, it is something that is done all the time. Yes, sir.
Now, this opinion of yours about the identification of this stain, you discussed that opinion with Mr. Baez back in 2008, didn't you?
Didn't you?
Yes, I believe I said I did.
So why didn't you put it in your report?
Product.
Overruled.
So
That's the
what-
reasons why you didn't put it in the report.
So if you discussed it with counsel, why didn't you put it in your report?
It didn't go into the report because my report specifically focused on the insects recovered from the trunk. And because those insects were not of a medical, legal, or forensic nature, there was no reason to make any further assumptions regarding a body in the trunk.
There you go.
Weren't you
great
instructed
answer.
that every opinion that you
That
were
was a
going to
great
issue in this
answer.
case was to be included in a report?
Y'all, did you guys hear that? That was a great answer.
Okay, here we go. So we are on to the next episode, guys. Woo! Here we go. Hang on just a second. Sorry, guys, it's not letting me click on anything. Hold on just a second here. Okay, hang on. Here we go. Okay.
My name is Dr. William Cesar, CEASOR, Renato, RANATO, Rodriguez, RODRIGUEZ III.
Wow, that's a
You
name.
may proceed.
Please
Holy
support
mackerel.
Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Dr. Rodriguez.
Good morning.
Sir, can you please tell us what your occupation is?
First, for the court record, if I may state, I am here as a unpaid consultant, and my
Objection, not responsive.
Oh my
Sustain.
God.
Listen closely to the questions and answer only
Oh,
the
boy.
questions that I asked you, sir.
Oh boy.
Can you give us your occupation,
Okay.
sir?
yes, I'm a forensic anthropologist.
And where are you employed?
I employed with the Department of Defense.
Okay, hold on. So first of all, so we got a forensic anthropologist. Okay, so y'all remember this is happening literally directly after that witness that we just finished, right? When this happened, right? So they just finished with so remember all those spicy, crazy interactions that you just saw, right? That's there was I don't even think there was a break in between because they had already broken for lunch. So already you guys can see where Mr. Ashton already was all worked up or whatever. Judge Belvin's already been getting sassy, and all that's going to give us context for what happens with this witness here.
Armed Forces Medical Examiner's Office in Washington, D.C.
And are you here as an unpaid consultant?
I am.
Okay. And how long have you been employed with the U.S. Armed Forces Medical Examiner's Office?
For about 23 years.
Okay. And what did you do before that?
Before that, I served as the forensic anthropologist and chief of operations for the Onondaga County Medical Examiner's Office. That's ONANDAGA, which is located in Syracuse, New York, and was responsible for the forensic anthropology for that office and the surrounding county in Syracuse, New York, and several other counties that we contracted to do the forensic services.
Can I get you to put the microphone a little closer to you?
Sure.
The acoustics are really bad in this room. So. Okay. Sir, can you share with the ladies and gentlemen of the jury your educational background?
Yes, I received
I think he has sailboats on his tie.
my BA, MA, and doctorate from the University of Tennessee at Knoxville, receiving my doctorate in 1985. And from there, went on to my first professional employment, which was with the Caddo Parish, that's the CADDO Parish Coroner's Office in Shreveport, Louisiana, where I served as the forensic anthropologist and chief deputy coroner for that parish. And as part of my job, within that particular office, we served about 2/3 of the state of Louisiana.
Are you a co-founder of the Forensic Anthropology?
Oh my God, look at Mr. Baez's tie, you guys. That tie is on fire. Or sorry, that tie is fire. There we go.
Research facility at the University of Tennessee?
Yes, I am.
Is that also known as the Body Farm?
Correct.
Oh boy. And so now we get to where guess who's there? That's Dr. Vass, right? So I wondered, are they colleagues? I'm sure they brought him on purpose. Oh my God. Okay.
How did that get started? How did you start that?
That was actually the idea of Dr. William Bass, who was my chief member professor at the time at the University of Tennessee. We were in his office one day discussing about time since death, which was a question that is commonly encountered forensic sciences.
What year was this? I'm sorry.
This was in the early 80s.
This is really interesting because we heard this story from Dr. Vass telling it earlier in the trial. And now we're hearing it from the other guy, right? Because we knew it was a conversation. Wow. Interesting.
Okay, go on.
And as we were batting it around in the office, we were discussing, how could we get some better understanding of the human decomposition, how it relates to time since death. And as we were discussing it, Dr. Bass said, well, the only way that we could do this is basically actually study the process of human decomposition. And to do so, we needed to start research and experiments. And so he recruited me into this project to actually build the decompositional facility and start the first research.
Wow.
And you put up the fences.
I put up the fences, helped lay the concrete, brought in the first bodies, and began to conduct the very first experiments.
And who wrote the first publications from the
I was the senior author on the first publications.
Okay.
Wow.
And since then, what kind of experience have you had with human decomposition?
Well, I've had extensive experience in human decomposition as a forensic anthropologist with my 3 years in the Caddo Parish Coroner's Office, where we deal in a very kind of a subtropical climate. Decomposition was quite evident in many of our cases throughout the state, and when we're dealing with decomposed remains because of the heat and the humidity and the insect populations. And then in upstate New York, I saw similar types of bodies. And then during my 23 years with the government, I've traveled all over the world and looking at various types of bodies and various stages of decays in all environmental conditions that one could possibly think of.
And where have you traveled to consult on well, let me actually ask you this before that. What is taphonomy?
Taphonomy is basically the study of the breakdown of an organism after death, basically what happens to that organism and how it's recycled by nature.
Okay. And do you have extensive research in that area?
Yes, I do.
Okay. And can you give us some examples of some of how many publications have you had on the topic?
I've had two that I initially came from the Body Farm. I have a chapter in dealing with decomposition and forensic entomology in the second edition of Medical Legal Investigations by Spitz and Fisher. And I have given numerous papers on a yearly basis to the National Academy of Forensic Sciences and the National Association of Medical Examiners on various cases involving decomposition. And how did forensic entomology begin? Well, basic forensic entomology basically has its roots in Europe.
So now, again, forensic entomology. So we just heard from the bug dude. But yeah, so that's just for anyone who, just to put two and two together there, because we don't always hear about it. So forensic entomology, that's the study of the bugs. And we just heard from him on the last episode, and we saw that recap too. So.
Began early in time in America, but it wasn't really that well founded. And it really wasn't until the time of the decompositional research at the Decay facility at the University of Tennessee, in which the entomology movement and forensic entomology here in the United States really got started. A colleague of mine that I ended up meeting during that time, Dr. Lee Goff, who's probably considered one of the most eminent forensic entomologists in the country, who's out of Hawaii, was very interested in this research, as well as a number of his colleagues. And we began to meet and talk about our research, since I had looked at insect activity as it related to decomposing bodies. And as a result of, I helped them found their American Board of Forensic Entomology.
So would you say you have extensive experience in the area of entomology as well?
Yes, as far as insects and being involved in the activity in which decomposition occurs and those insects are attracted in.
Have you lectured in the area of entomology, taphonomy, and anthropology?
Yes, I have on many occasions.
Okay. Have you been admitted in any courts as an expert witness on those topics?
Yes, I have.
Okay. How many times?
Numerous.
Can you give us just a ballpark?
I would say in the realm of 100 or more, conservatively.
Okay. At this time, Your Honor, I would move to have Dr. Rodriguez admitted as an expert in taphonomy, entomology, and forensic anthropology.
May I vote aye on the entomology issue, Your Honor?
You may.
Interesting.
May I just do it from here?
You may.
Microphone.
So interesting that they want to offer him as an expert in both fields. And maybe this is the next day, actually, because now I'm like looking at it, and I think that's a different tie that Mr. Ashton has on. That's how sometimes you can tell, right? Is based on if you've got men doing the questioning. It's like, okay, is it the same tie or not? Let's see.
How many times have you been qualified as an expert specifically in the area of entomology?
I have not been qualified as an
That's a different tie. So, okay, so this is the next day. Okay.
expert in the specific field of entomology, but in the use of insects in determination of time since death and decomposition process.
Your Honor, I have no objection to his qualifications in the area of taphonomy and forensic anthropology, and to the extent that insects are involved in taphonomy in that area. But in entomology generally, I do object.
Your Honor, he has testified that he has helped establish the American Board of Forensic Entomology. The research that began entomology came from his.
Oh my God. Can we see that again? No, hold on.
Yeah, but in entomology generally, I do object.
Excuse me.
Your Honor, he has testified that he has helped establish the American Board of Forensic Entomology. The research that began entomology came from his.
Get over here. Oh my God. Look at his face. Oh my God.
Thank
I
you,
love
sir.
this so much.
Dr. Rodriguez, can you give us,
Y'all.
can you tell us a little bit more about your experience in forensic entomology?
And the thing is everybody's getting, at this point in trial, right? Everybody's getting tired. Remember, because the jury's sequestered, they're also having court on Saturdays as well. So they're going 6 days a week. Everybody's getting tired. Mr. Ashton's getting testier and testier. Judge Belvin's getting, fed up with some of the shenanigans. Anyway, this that there's a reason I call this again defense expert drama, because there's a lot that goes on this day.
Again, early in the decompositional research that was conducted at the body farm, my primary.
Could you put the microphone a little closer? Sorry.
My primary area of study was looking at the insects and documenting the various insects that inhabited the body, their activity on the body, their reproduction on that body. And throughout my career, I have worked extensively with forensic entomologists in looking at this similar activity, collection of the insects, and an instruction to law enforcement on how to utilize and collect these insects in relationship to the decompositional process and utilize them for things such as time since death.
How many times have you consulted with law enforcement in the area of forensic entomology?
Hundreds.
Your Honor, at this time, I would move to have Dr. Rodriguez admitted as an expert in forensic entomology,
Your Honor,
as well as the other areas.
as I indicated, I have no objection to him testifying as to entomology as it relates to decomposition, but the broader field of entomology I would object to.
The witness will be accepted as an expert witness in the area tendered by the defense and may continue.
Okay, they won that one.
Sir, what information have you been given, or were you given in this case to review?
In this case, I received the documents and records pertaining to the medical examiner's report and findings of the examination of the deceased. I received the forensic anthropological report and their findings regarding the deceased. I also received the entomological report that was generated by Dr. Neil Haskell. And I also received photographs of the recovery and the scene, in addition to the photographs that were taken of the remains of the deceased at the medical examiner's office.
Now, did you also examine photographs of the medical examiner that they took at the medical examiner of the skull?
Yes, I did.
And also at the scene?
That's correct.
Okay. Tell the ladies and gentlemen of the jury any opinions that you may have that have to deal with the collection of the evidence at the scene.
The evidence collection appeared to be very thorough as far as collecting the skeletal remains anytime you're dealing in particular with the remains of a child, which have many, many more bones than the adult because they're still in the stage of development. Each of their bones are made of individual components. It is certainly difficult to deal with the recovery of the remains of a subadult. Since there are multiple bones. When you're in a wooded environment, of course, that area of search becomes much more difficult in trying. So in looking at the recovery, it looked to be fairly good. One of the things I noticed that I did not see in the report or dealing with the investigation is trying to determine the exact location of where that body may have initially been placed. This is something that I normally do on a regular basis because in dealing with skeletal remains that are outdoors and which they may have been exposed to carnivore or scavenging, the bones may be spread from the actual area where that body actually was placed or that body may have decomposed. And it's very important to try to locate that area of decomposition.
Why is it important to find the exact location?
Because when we want to define that area, that is where typically as the body decomposes, we may find much of the evidence related to not only the decomposition of the body, but various types of trace evidence. For example, if a body had been shot, if the bullet's contained within the body, as that body decomposes, that bullet will basically drop down through the body if it's not embedded in the bone and will work its way into the soil. Teeth, typically the anterior teeth that are single rooted as they fall out as a result of the ligaments within the dental arcade decompose. The front teeth many times will fall out when that skull is moved. And if there's any other trace evidence such as fibers, clothing, that is typically located and left at that scene. And so we also want to determine not only that evidence or to find that evidence, but it gives us a better idea where that body may have been initially placed that can help us in the investigation.
What could you have done? What could investigators have done to look for that? How would they find that? I don't understand.
In looking for those areas, typically, again, if you have a skeleton that has been dispersed, the area where that body initially...
Let me object and ask to avoid ire on the issue of whether can we approach? Need to make a...
Judge, I would object.
Yes.
Oh my God.
May approach.
Oh my God.
What would you look for to try and determine where the initial deposit site was?
What we would look for is areas where you have evidence of soil staining as a result of the decompositional fluids leaching out into the soil. It will actually change the consistency of the soil. It can change the vegetation by either increasing some of the vegetative growth that feed on some of this, and it will also kill some of the vegetative growth as a result of these fluids smothering. We will also see evidence if it is during the time of year when insects are prevalent. Carrion insects basically will feed and reproduce in that area, and their remains, such as the puparial cases, some of the insects that die during that process or become trapped in the fluids, basically will be found in that area of the soil. And so we look for these environmental changes that tell us that a decompositional event had occurred.
Okay. And did you see any photographs indicating any soil change throughout the scene?
I didn't see any.
Okay. And we don't know if they actually looked for that, but you certainly just didn't see any evidence in the photographs.
I didn't see anything in the report that noted that.
And would that be something that an anthropologist would note in their report?
I would hope they would.
Okay. Now, do you have any experience in finding remains with duct tape?
Yes, I've had numerous cases.
Okay. And what are some of the aspects that you take into consideration when looking at remains that may or may not have had duct tape, either to package them or to bound the victim?
I've looked at numerous cases in which the body has been bound in various ways, everything from wire, cloth, and those cases in which duct tape or other similar types of tapes have been employed primarily to bind the hands or to bind the head or the facial area. In looking at those types of cases and looking at the binding itself, when we have cases in which the body still has soft tissue on them and have begun earlier stages of the decay, we look at the positioning of the tape on the body to try to say exactly where that tape was actually bound to the body. And when we have cases when the body has basically undergone mummification, we get a very good idea of where the tape is, because basically it is attached still to the mummified tissues. In the cases of skeletalized remains that undergo, or basically a body that undergoes decomposition, as the result of decomposition, basically that will affect the adherence of that tape. And so one...
Oh, God.
I don't believe we do, Judge.
Folks, approach the sidebar and cut the comments out.
Oh, my God. Look at him. He's done. He's done. Oh, dear.
All right, Mr. Ashton, would you make your objection and so we can go through it by the numbers?
Yes, sir. The objection is that the opinion that is being offered by the witness at this time is not contained in his report of February 21st, 2011, which was provided pursuant to the court order, which specified that any opinion that the witness was going to give must be included in the, just a moment, I want to try to quote it. It had to be included in the report, as well as the factual basis for that opinion.
We know
there is no opinion
well,
in this report that references to duct tape.
Wasn't,
it is mentioned as a
in other
fact
words,
of the case, but there is no
what he's
opinion
getting at here is this is a new opinion. It wasn't in his report.
that references any interpretation of the duct tape or any background information, as the witness has just discussed,
So
about
come up
duct tape in other
us
cases.
in this trial and in all trials we always hear. So the question will be, is this a new opinion or not? They're gonna have to fight over it.
Mr. Baez?
Our position is, and our clear understanding of what the court's order was, is that if it was not submitted in the report or included in the witness's deposition, it would be precluded from trial.
Mr. Baez, pull out the court's order and read that portion
Dear
that you were
God.
talking about.
Oh dear.
And while you're trying to find that, let me ask the doctor some questions. Dr. Rodriguez, what opinion you were about to express dealing with the duct tape?
In reference to this particular case, Your Honor?
Yes, sir.
That the positioning of the duct tape as it was found, you can see in the photos there at the scene and the medical examiner's office that the duct tape is in two different positions. In a completely skeletalized remains, unless it is in a buried context, one cannot make a absolute finding as to the exact positioning of a duct tape as it is lost, its effectiveness and stickiness. One cannot make a determination as to the restriction of that duct tape, and certainly in decomposed remains in which they have skeletalized the soft tissue to which that duct tape was attached, and the movement of those remains by animals basically precludes anyone from making any scientific conclusion as to the actual position of that duct tape, whether it was around the areas of the eyes, did it cover the areas of the nose and the mouth, did it just cover the areas of the mouth. In cases that I have had, have only been able to conclude the actual positioning of that duct tape in a case of a burial in which basically it is held in context by the soil, or in a mummified body in which the soft tissues basically have dried out and the duct tape is still adhering.
Doctor, when did you formulate that opinion that you just shared with us?
Early on when I saw the pictures.
Okay. Specifically, what do you mean by early on?
When I received the first pictures from Mr. Baez.
Okay. I don't know the date, Doctor. So
the photographs were given to me earlier this year, right prior to my report, which was dated February 21st.
Was there any particular reason why you did not include that portion that you just told us about in your report, sir?
I didn't mention it because it was a non-issue. Because in looking at these types of cases, there's no scenario where you can make a definitive answer, and so basically I wasn't asked at that time anything about the duct tape. It was just something that I had noted in my examination.
Okay.
You noted it in your examination, but you did not include it in your report.
That's correct, sir.
Okay. Did you share that opinion with anyone on the defense team?
I did.
Who?
Mr. Baez.
When?
It was at one of the telephone conversations that we had after my report.
Was it in January or February of 2011?
I believe it was February of 2007.
Were you ever informed by the defense team or Mr. Baez in particular of this court's order requiring all opinions that experts are to give in this case to be placed into their reports?
I was not aware of that, sir.
Okay. Were you ever shown the copy of this court's order or informed of this court's order, the one that I've just mentioned, about experts being required to put all opinions that they will testify to within a written report, or face the possibility of having that opinion not being given in court?
No, sir, I was not made aware of that.
Okay. So Mr. Baez never informed you of this court's order?
That's correct.
Okay. Thank you, Dr. Rodriguez.
I have a question, Judge, on those topics.
Go ahead.
Dr. Rodriguez, do you recall getting some emails from me just before you were asking you to submit a report?
That's correct.
And if you can recall, can you tell the court if I had informed you that the court issued an order requiring all experts to issue reports expressing all of their opinions?
Yes.
Okay. And the communication that you and I had on this topic was via those emails, correct?
That's correct.
Okay. And when we met 2 nights ago, did we not?
We did.
Okay. And was that determination made that is something that we wanted to have you testify about? Or was it prior to that?
It was at that time.
Okay. And was that as a result to rebut what Dr. Warren had? Well, let me rephrase that. Was that? Do you know if this was in an attempt to rebut what we thought was testimony that was not true?
I was informed at that meeting about the superimposition. That was the first I heard about the superimposition done by Dr. Warren.
And do you have an opinion as to what that if a forensic anthropologist should do a superimposition?
That's correct.
Okay. What is that opinion?
In doing a superimposition is typically used to provide some type of tentative ID, basically identifying a victim by superimposing a skull over a photograph of the victim. utilizing it to show or positioning of a duct tape and skeletalized remains is unheard of as far as I am concerned, because there's no way scientifically that you can show where that duct tape was. Basically, you can take that duct tape.
So what they're talking about is, this feels like a long time ago, but in the state's case in chief, they had, they brought in like several forensic anthropologists, and one of them was the dude who did that superimposition. And there was a lot, they had a huge thing outside the presence of the jury with that one, with that video that he made that they didn't show us because it had to do with this. Well, I don't know that it was the actual skull, but it was, in other words, it wasn't, we didn't see it, but we heard them talking about it. So that's what I wanted to mention, is that's what they're talking about here, is this, this superimposition where he, took the duct tape and tried to show what it would have looked like in real life or whatever. And it seemed kind of iffy in my opinion. I didn't know that this guy was going to come in, but at the time I thought, it seemed kind of like, I remember him saying something like he didn't have the measurements and it wasn't a scale, and it's like, but anyway, so that's what they're talking about here.
And you can reposition it anywhere on the body because you have skeletalized remains. It has been moved by animals. Therefore, even I, as a practicing forensic anthropologist, all I could say is there's duct tape in association that was most likely somewhere around the head. I cannot actually tell the position of it. I would be stepping off of scientific foundation if I were to do so.
Your Honor, the issue of all of this, when the court issued its order, I informed all of our experts via email, clearly expressing that we needed reports from them, because originally we had not asked them to do so, and that all opinions that they were going to testify to should be included in the reports. Furthermore, I informed them that they had a deadline, and that if that deadline was not met, that I would suffer dire consequences. You may recall that not only was I sanctioned, we were dead set on making all of the deadlines in which we did. From the time that I asked Dr. Rodriguez to write his report until the time he actually wrote it, it was a matter of days. I believe the court gave us 20 days or something like that, maybe a little more. I'm not exactly certain. This was a very difficult task for us to do, considering that all of our experts are extremely busy, that have multiple caseloads, and of course the time constraints that were placed upon us. Furthermore, when we were never given this video superimposition during the photo CDs that the state had.
I'm not concerned about the superimposition.
Well, that's what I'm trying to get to, Judge.
Yeah, I knew he was going to say that, because the thing is that already happened. That ship has sailed. But that is interesting. What he's mentioning is that their experts only had 20 some days to prepare their reports, because initially they weren't. So remember, as it comes to expert witnesses, right? The rules are generally that some states might have more restrictive rules, but going from the federal, the FCRIMP, as I always call it, the state, they have to require reports for their expert witnesses. But for the defense, I believe the rule is it doesn't require a report. It requires their CV and what the data they used and their methodology and stuff like that, but it doesn't require a report. And the reason being is that it's really expensive, right? Those expert reports, as you guys I'm sure are well aware, it's a huge deal. And normally, they take months, if not longer, right? That's the whole to make these reports, and they're a huge deal. And then if they have to issue a supplemental report, that's another huge deal. And that costs a lot of money. And so I would imagine that that's why for defense, right, the rule doesn't require that, because because they don't have, that would be unfairly prejudicial, especially if you're working on a budget, which defense attorneys are. So, so they, instead they have those other things that they require that don't cost as much money. And so you'll actually hear oftentimes in trials where it's a defense expert, right? And the prosecution's like, and you didn't write a report. And why didn't you write a report, right? And they're like, well, we weren't asked to. And it's supposed to look bad in front of the jury, which the jury might think looks bad, right? But, the thing is that it's kind of weaselly, right? Because they're not required to. The reason they weren't asked is because they aren't required to. So that's just one of those things, though, that you'll hear people always go back and forth about their reports. And in civil cases, expert witnesses on both sides, whether you're the plaintiff or the defendant, they are required. So in that, I wanted to say all of that to frame that this is unique here, where like that. And so that's why the reason why they weren't asked to write reports initially is because it's not required. So what happened in this case is that there was a court order by Judge Belvin, I guess 20 some days before the trial or what have you, right? Where he said he was going to require reports from the defense experts as well. That was his choice. And so they had very little time to put those reports together. Yeah.
What happened was we did not anticipate this testimony from Dr. Warren. It occurred when I met with my witness. I expressed and asked him for opinions on those, and that's what he's rendering.
So the doctor is mistaken or misinformed when he says he told you this in January or February of 2011.
Oh boy.
That's what you're saying.
I'm not saying that. But I can tell you this. We've discussed numerous aspects of this case, and there are numerous aspects that are not included in his report, nor will he testify to. So, I mean, to sit there and ask him, everything you've told me, make sure you put in your report. I don't think that's reasonable. What is not reasonable as well, Judge, is that an important witness on a case like this should have been deposed. They chose not to, and your order says, and I will read as instructed, opinions that are not expressed in a written report or at depositions taken during the discovery will not be allowed at trial. I asked during a status hearing, what if they choose to not take someone's deposition? That's going to limit these people's testimony. It's going to create due process issues. And every bit of testimony is important, as is this. And I don't have Mr. Ashton's exact quote, but he claimed that they were going to take the depositions, but that this wasn't going to be some kind of trick that we were going to play with the reports. My response to that would be, my response to that was something along the lines of, no one's playing games here, just that if they're going, and it's hard for me to make representations without the exact recollection, Judge, but my understanding and the purpose I brought this up was they were going to try and play a pull a fast one by saying, well, if it's not in the report, that's it. I'm not.
Okay, so remember what they said at the beginning of this, outside the presence of the jury that we're in right now, is that Mr. Baez and the other defense attorneys are trying to find the exact order from the judge, right? They're still looking for it. But Mr. Baez said his recollection of the order, right, was that it had to be in their report or if they had testified to that opinion at a deposition. Now, that to me made sense because we've heard this come up before with the other expert witnesses where they've said something like, oh, this was in the deposition. And if it was in the deposition, it was allowed in. So if anyone that's been watching this with us, you'd be familiar, like that's come up a number of times. And that's why they do these depositions. So what he's saying here is that it sounds like when offered the opportunity to depose this witness, Mr. Ashton chose not to. And so remember, he's got this opinion that's not in his report, but it's almost like it would have come out in deposition, but Mr. Ashton chose not to. So now this is where he's talking about the playing games thing, where it's like Mr. Ashton could say, well, it wasn't, if it's not in the report, it's not in the report, right? It's like, well, if the order does say, as Mr. Baez has represented, that if it's in the report or at deposition, then you're in a bit of a pickle if you choose not, if they were chosen. You can see where it would be a thing, right? Or if they didn't depose them when they could have and maybe should have. Now we're in a gray area, and whose fault is that, right? Is the fault on, well, the state didn't depose them, or is the fault going to be, well, too bad it's not in the report, so we'll see.
Why should I take their deposition and then allow them to testify about more things?
Right.
Do we have to, in a unique situation where the court is ordered?
Like it could be getting into Richardson hearing territory. For you guys who watched Sarah Boone, you would recall that happened.
Something. Now start taking depositions of our own witnesses. I sat in hundreds of depositions in this case, not because I wanted to, but because it was my responsibility to do so. And
it's not the defense's job to call a deposition. Remember, depositions are expensive. It's the other party, the party that it's for the opposing party, right? They're the ones that have to pay for the deposition and call the deposition. And so that wasn't his responsibility. That was Mr. Ashton's responsibility.
Also taking depositions while this trial is pending. If this is an issue so concerned by the state, as to make sure that they know everything that this witness may or may not testify to. They should exercise what tools are given to them and take the deposition to do the work.
So they didn't.
Well, Mr. Baez, I want to ask you the same question I asked you earlier at the sidebar. What you're basically saying, sir, is that you can pick which court orders you comply with and which court orders you don't comply with. And that's not going to happen here.
I couldn't disagree with you more, Your Honor.
Well,
Respectfully.
Mr. Baez, to be quite frank, both sides
Okay,
have engaged in what I call game plan.
here we go.
Okay. And this is not a game. And the reason the order was entered in the first place was because both sides were engaged in some form of it at some time. And the reason the order was entered is because I did not want to be at the position I am currently in now. Is that we have experts with no opinions, major opinions that are not contained in their reports. And the easy thing is if a report comes about or if opinion comes about, you disclose it. It's not hard to do, Mr. Baez. It is quite easy to do. Even if it happens at the last minute. So here am I faced with what is the remedy? It's quite ironic that we were scheduled to be here at 8:30 this morning to talk about a possible violation of the rule of sequestration. You go back, you review the cases. And all of the cases seem to say that exclusion of the witness from testifying is a very extreme and harsh rule that is not to be done except in the most aggravated situations. But they list a couple of other things that you can do. It appears to me that this was quite intentional. This was not some inadvertent slip.
Wow.
This was not some sub-issue of a major issue.
Oh dear.
It was not inadvertent.
So there, I believe he's found the judge's order.
The question is whether or not Ms. Anthony should be punished as a result of this. The case law seems to indicate the following: contempt, an instruction to the jury concerning the violation that has occurred, and let them use it in judging the credibility or believability. So what other opinions is this witness going to give that has not been disclosed in his report?
I will also.
Well, this is what I'm going to do. What other witnesses you have available for the day?
We have Dr. Spitz as well.
Okay. This is what we're going to do. We're going to stop today at 1 o'clock. This witness is going to step down. You can take his deposition this afternoon.
This is just like what happened in Sarah Boone. How funny. So remember how that happened? Mr. Owens took that deposition during trial with that, like the psychologist or whatever. Same thing. And that way you can get that's the remedy. Now, again, here in this case, that just goes to show you, right? It's interesting that he's really mad at the defense when it seems like Mr. Ashton should have deposed this witness and he didn't. And how do we know that? Well, because the remedy is to depose him. This is so funny. This is exactly what happened with Sarah Boone, where they were giving a new opinion. And it's interesting because sometimes you hear where it's like, like with these other expert witnesses, sometimes it's like they just can't testify to that opinion, right? But I think the difference is when the opinion had been disclosed, but it wasn't in the report. And here he's saying it wasn't disclosed. And it sounds like he's saying too, like if he had disclosed it, it would have been different. So, so now I think that it's more like now we have to see what else could come out, right? It's in the event that there is some gamesmanship, right? And there's other things that were talked about, you know, but we don't know what we don't know. And that's what the deposition is for. That's your chance to so that's what's going to happen. Interesting though. So they're going to take him off the stand. And then Dr. Spitz is the forensic pathologist, if I recall, for the defense.
And he will testify one day next week, Monday. I would entertain a possible instruction if the state wants to draft one about this violation, and I will decide whether or not I will do it. I will reserve the decision whether or not I should proceed to contempt proceedings at the conclusion of this trial.
I would request that the court also look at the answer filed by the defense, where I clearly laid out that Dr. Rodriguez would be called also to rebut any issues raised by the prosecution in trial. This does fall under that category. And
Mr. Baez, this is not my first rodeo. And let me say this, sir. I've tried one or two cases.
Oh boy.
As a lawyer.
Here we go.
And
he's getting scolded.
there was a case that I tried called the case of the state of Florida versus
There's a guy in the audience trying not to laugh. It looks like back there.
Judy Pointiano. At the conclusion of the defense's opening statement, and after the first 10 questions that the defense asked in cross-examination, I found myself in a boat without a paddle, because they raised the issue that you could not tell that they were raising up until the time they asked certain questions. And at that noon recess, I asked my investigator to find certain things out. By 4 o'clock that afternoon, my investigator had located about 4 or 5 additional expert witnesses. I talked to them that night. The next morning in court, I filed a supplemental discovery of those witnesses, and I set them all up for depositions the following evening, so the defense would have an opportunity to take those witnesses' depositions to determine what they would testify to. So the defendant would not be surprised. All my order simply tried to do was to give both sides an opportunity to know what each expert would testify to, so they could prepare. So we would not have.
And is where I feel like shouldn't he be directing this at Mr. Ashton? Because I agree with what he's saying. That's great. But Mr. Ashton did not depose the witness. So,
no gotcha moments where someone would be caught unprepared. So what we would do is we will take a 10-minute recess, and Dr. Rodriguez be prepared to give a deposition this afternoon at 1 o'clock. And then we can ferret out all of this. But let me say this.
Oh boy.
Lightning does not strike twice in the same place.
Okay.
Even though the case law says you can't be punished by exclusion the first time, if there are other opinions that you know that he's going to give, they need to be laid out. Because I am not making any promises or warranties about what I would do if it happens a second time with this witness.
we would like to place the state on notice that we're going to take our own experts' depositions at the conclusion of today. If they wish to be present, they can be present. And we will
Well,
give
you
them
don't
a
have to
copy.
take your own expert's deposition. I'm making him available for the state to take his deposition. It would be totally unfair to Ms. Anthony to have his testimony excluded on this critical issue. But we will deal with the after effects afterwards, and that's the remedy that I have chosen to give. We'll be in recess until 5 minutes to the hour.
Oh, sorry, inhaled my water. Okay, let's pull up the next witness, guys. Give me just a second here. Where is he? There he is. Okay, cool.
Werner, ERNER, Spitz, S.
So he has a very strong accent. But he is, if I recall, he's like the Dr. Russell in this trial, as in Dr. Russell from Karen Reed, where he's like done like fucking everything. And he's like so extremely overqualified. It's insane. So yeah.
PITZ.
You may proceed, Mr.
Good morning, Dr. Spitz. Could you tell us, sir, a little bit about just who you are? What is your profession, sir?
I'm a medical doctor and I'm a forensic pathologist.
I know it may take a little while, but I do want to go through your academic training and background. Could you tell me, sir, where you went to medical school and when?
I went to medical school at the University of Geneva, Switzerland, School of Medicine from 1946 to 1950. And then I transferred to the Hebrew University Hadassah Medical School in Jerusalem at that time, at that time it was before the State of Israel was established, so it was Palestine until 1948, and then from 1948 it became Israel. And I graduated from that university in 1953 and received my diploma to practice medicine.
Where did you do your internship, sir?
I did my internship at that same university where I graduated. And that internship was 1 year. And then after that year, I did a residency. And that residency was in pathology and lasted for another 5 years. And then during that time, I did a residency in pathology and forensic pathology. Pathology is what is practiced in a hospital where a physician examines tissues and body fluids to determine the nature of disease. And if a person dies, then pursuant to request of the next of kin, that same doctor can perform an autopsy. Usually in hospitals, when a person dies and an autopsy is performed, that autopsy is for educational purposes so that the doctors understand the mechanism of the disease, the condition that the person died from. Forensic pathology, on the other hand, is the science where a pathologist, he has to be a pathologist first. A pathologist will examine a body, usually, not always, but usually, do an autopsy pursuant to the state law. Mm-hmm. And he does not need a permission from the next of kin. And such a person will usually do an autopsy on what we call police cases which are suspicious, where somebody dies.
Right, and that's why they have to determine cause and manner of death, right? So in other words, if somebody just dies from like whatever, a heart attack or, there's nothing, then they don't do it, right? Unless it's asked for by the next of kin. So that's what he's getting to here.
Where there is no medical doctor in attendance, where we don't know why that person died. Yep. And usually these are either accidents, suicides, yep, homicides, or natural death.
Dr. Spitz, when did you have your first appointment in the world of academia? That is, as a faculty member? You remember?
Yes, I was appointed to let me say this, if I may. In 1959, I came to the United States, and as I came to the United States, I came on a. I was paid by a grant from the University of Maryland, where I held an academic appointment and worked at the medical examiner's office for the state of Maryland in Baltimore.
That was in 1959?
That was in 1959.
Wow. Did you subsequently become a member of the faculty in Berlin?
In 1961, I think it was, I left this country and worked for 2 years and 3 months at the University Medical School of Berlin in Germany. And there I held an academic appointment too at the university.
Did you thereafter return to the University of Maryland?
Then after 2 years and 3 months, I returned to the United States, to Baltimore, to the medical examiner's office of the state of Maryland. And at that time, I held an academic appointment. In fact, I was associate professor at the Johns Hopkins University and also at the University of Maryland.
Wow.
Those basically during the same time, Johns Hopkins and University of Maryland?
I held 3 appointments. I was associate professor at the University of Maryland, an associate professor at Johns Hopkins University, and I was assistant medical examiner and later deputy chief medical examiner for the state of Maryland at the office of the chief medical examiner.
Wow. Are you presently associated as a professor within a university?
Yes. Then in 1972, I went to the medical examiner's office of Wayne County, which is in Michigan, in Detroit. And I was appointed chief medical examiner there. In fact,
you can imagine already we heard Baltimore and Detroit, right? And those are 2 of the cities in the entire US that have like the highest crime rate. I think maybe the highest like homicide rate. So thinking about just the amount of autopsies he's done, right, is, yeah.
That is why I went to Detroit. And also I was associate professor for a while, and then I was appointed to full professorship at the Wayne State University School of Medicine. I also held an appointment as adjunct professor of chemistry and taught toxicology at the University of Windsor in Windsor, Ontario, Canada, across the river from Detroit.
Oh, okay. Right.
Are you still associated with the University of Windsor in Ontario, Canada?
Yes, I am, but only because I think by name or in name, because I have not taught there actually probably in the last 10 years.
Have you been, sir, the medical examiner or assistant medical examiner for the state of Maryland?
Yes, I was assistant medical examiner for the state of Maryland for approximately assistant and then deputy chief medical examiner. And the chief was quite sick, so I was quite active filling in for him for approximately 12 years.
Wow.
Have you also been the chief medical examiner for Macomb County in Michigan?
Yes, I was. When I first came to Michigan as chief medical examiner for Wayne County, the county of Macomb, which is a little bit to the northeast of Detroit, asked me if I would do their autopsies for them. They had a chief medical examiner, but the chief medical examiner there was not a pathologist. So he needed a pathologist to tell him what people died from and what he thought was the manner of death, meaning homicide, suicide, natural causes, or accident. So they appointed me to do that work. But then that medical examiner died, and I became the chief medical examiner for Macomb County as well.
So, yeah, I was just going to say, that's really interesting. I don't think that's allowed anymore because, we've talked a lot about this with other cases. And, Murdoch is where we really delved into it, right? Coroner versus forensic pathologist versus medical examiner. And today, right, medical examiner, you have to be a forensic pathologist. That's a requirement. So that's really crazy. I was surprised to hear that. So,
are you a fellow in the College of American Pathologists, sir?
Yes.
Are you a fellow in the American Society of Clinical Pathologists?
Yes. These appointments now are emeritus appointments. That means I do not have to pay dues anymore.
Well, 4 years enough?
I'm sorry?
Never mind. Are you on the board of directors of the National Association of Medical Examiners?
I was. I'm not any longer. Yes.
Are you a fellow of the American Academy of Forensic Sciences?
Yes.
And
actually, I'm a fellow. A fellow is because I've been associated with the Society of Forensic Sciences for so long, I was appointed fellow, which is a higher level.
And have you served as vice president of the World Congress of Legal Medicine?
Yes, I still do.
Wow.
Are you licensed to practice medicine in the member countries of the European Union?
Yes, in all the European countries that are members in the European Union. Yes, that's
Wow.
correct. But I'm also licensed in this country, in Michigan,
I would hope so.
in Virginia, in the District of Columbia, and in Maryland. District of Columbia meaning Washington, D.C.
Have you received recognition and awards in connection with your professional work, sir?
I have received quite a number of awards, yes.
He's a G.
I don't want to test your memory against mine, so I'll read and ask you some of them, okay?
Yes,
Did you attend and receive an award in recognition for the National Association of Medical Examiners back in 1972?
I probably would answer that by saying to you that I really don't remember, but I probably did.
Have you received various awards from law enforcement communities and activities?
Yes, I did. These awards from law enforcement is because I received awards from local police. I received award from the FBI. I received awards from all various types of law enforcement organizations, primarily because I give courses to them and I give lectures and serve as consultant to them when they ask me to interpret various cases.
Would that category include the New York State Police,
Yes,
Wayne County Medical Society,
yes,
Sterling Heights Citizens Police Academy?
yes.
American,
They're not all listed, so you don't need to make an effort.
Amazing.
have you also been consultant, sir, for various organizations and universities?
Yes, I have.
Were you a special consultant for Johns Hopkins University?
Yes,
How about the Veterans Administration?
that as well.
And sir, were you a special consultant for the Rockefeller Commission?
Yes, I was.
What was the Rockefeller Commission, Dr. Spitz?
What that was?
Yes, sir.
The Rockefeller Commission is the commission of Vice President Nelson Rockefeller when he was alive, and it concerned itself with the assassination of President Kennedy, the reconstruction of the events that occurred that day in Dallas, and how the president was killed.
Were you also a member of the Forensic Pathology Panel Select Committee on Assassinations for the United States House of Representatives?
Yes, and I testified to the House of Representatives on the issues of the assassination of Martin Luther King and John F. Kennedy.
So in other words, if he's good enough to determine the cause and manner of death for like assassinations of John F. Kennedy and Martin Luther King and testified before, what was it, before Congress, I believe he said, then he's good enough to work on this case. Let's just make, was it, oh, House, sorry. Yeah, that's, they're part of Congress. Yeah, House of Representatives, correct. They're part of Congress. See, I know things. Thinking back to like elementary school when you learn that type of stuff.
I testified to the House of Representatives
There we go.
on the issues of the assassination of Martin Luther King and John F. Kennedy.
Were you involved, sir, as a professional pathologist in a case involving a young woman named Mary Jo Kopechne?
Yes, I testified in a trial.
I would have an objection at this point. This goes beyond his training experience in the area of forensic pathology.
Sustain this to the last question.
What other major
Okay, so I was wondering, I was like, I don't know who that, I didn't know that name, but I figured it was probably a high profile.
trials, sir, have you been involved in that the folks in this courtroom might recognize you for?
Same objection, Judge.
By that, he means the jury. Interesting. So, we see this sometimes where it's like, we get it, he's qualified. And so sometimes, I've seen this before where they'll object and they'll say, we're entitled to present their more qualifications than we already have. Because part of it too is right. Like you pay a lot of money for these experts. You want to show the jury why they're so qualified. But I think at this point, I think there's no disputing that it's sufficient. So,
Doctor, have you published various articles, books, lectures, publications?
I have.
Do you know how many?
I've published 4 books, textbooks, and the last one was in 2006.
Is this one of them?
Wow.
Yes, that's correct. That's the last book.
Look at this. Look at this. This is awesome. Look at all those Post-it notes. They're going to be using this book that he wrote. Amazing.
Yes, that's correct.
Love that.
That's the last book. The last book.
Hefty too.
have you published articles in connection with such things as the mechanism of death in freshwater drowning?
Yes, I published approximately 14 articles related to the subject matter of drowning. And
Okay, I've been waiting for this. So I have been waiting for this. Long time ago, you know, we've been talking about, you know, what happened to Caylee, right? You know, because the Dr. G, right? Dr. Garavalia or whatever, she, you know, the for her, you know, it was undetermined, right? So the cause was homicide by undetermined means. No, sorry, the cause was undetermined and the manner was homicide by undetermined means. Okay. And I thought to myself, damn, if they don't bring in, like, isn't this going to be insane? Like, I was like thinking, if they can bring in a forensic pathologist who's obviously credible, right? And they can say that something different and that they see signs that could point to drowning. I mean, I don't think it's even needed at this point. But also, shame on the state, right? Because that was the first thing that anybody thought happened, as we've heard about a ton already in this trial, based on Cindy from day one mentioning the shit about the pool with the ladder gate, right? And so that was like the first theory of what happened. And it's so interesting that the state just completely, you know, ignored that, or because they had Casey there and that, you know, and they thought she was, you know, lying and whatnot, because, you know, at that point in time, right? Like when Caylee was first reported missing and when Cindy was talking about Laddergate, right? And they did that interrogation with Casey. Of course, they didn't find the body until 6 months later. So it's so crazy to think about how quickly that they just shot down it didn't even worry. Like, in other words, without having the body, they should have, logic would be, well, it could have been a drowning. We don't know, right? Because we don't have the body yet. But incredible that they just ignored that and went with, well, we've got, you know, Casey and, you know, we think she's involved in blah, blah. So anyway, but all that to say that it almost seemed, in my mind, I thought it would almost be so shocking to hear that someone could find that it could have been drowning. And by shocking, what I mean is this, because it would be so shocking that that is the case and that the state ignored that. Like, you know what I mean? If that makes sense. Because everything was pointing to that from the get-go. Anyway, so.
Those were published in, as far as I can remember, peer-reviewed journals. And this is part of my publication list of where I published 96 scientific articles, peer-reviewed by other pathologists to determine that they were suitable and recommended for publication.
Sure, have you?
I wonder too if it's going to be a thing of like comparing the experience too, right? Like, for example, if he has, for whatever reason, maybe he's got even more experience with victims of drowning, or, you know, like whatever the languaging he used, bodies that are found in water, you know, versus like Dr. G, and that they can explain maybe that's why she didn't see it, if indeed that is what he's going to testify to, but that's what it's pointing to.
Testified as an expert witness in the courts in the United States.
Yes, I have. I have testified on what I think, what I think to remember in all 50 states, including Alaska and Hawaii.
And have you also testified?
Is the first time I've ever heard that from an expert witness. I mean, that's insane. All 50 states.
As an expert in foreign countries.
Yes, I have. I have testified in Canada. I've testified in the Middle East. I've testified in Europe. And I've testified in, well, not testified, but I've done work for the United Nations and then given opinions to a court in Costa Rica.
In just the last 7 years update of your curriculum vitae, sir, do you know how many times you've testified as an expert witness?
Probably around 300 times. Maybe somewhat more. I testified probably around 30 times on the average, a year. But there have been years in which it was more frequent, so that would probably exceed that number if I actually counted it.
Your Honor, I think that's enough. I request to certify and direct the recognition of Dr. Spitz as an expert witness in the field of forensic pathology.
What says the state?
No objection.
Ladies and gentlemen of the jury, Dr. Spitz will be accepted as an expert witness in the area of forensic pathology. You may proceed.
Do you remember, sir, when and how you first got involved or became involved with the case we're here for, State of Florida versus Casey Anthony?
I received a call, I think, from the Jose Baez law firm.
And what?
And I was asked to possibly, if I agreed to consult with the firm on this case, and also whether I have special requests that they would.
Your Honor, let me object. Is hearsay and not responsive to the question of how you first contacted.
What was the first thing that you did, sir, after speaking with the Baez law firm?
I requested to attend the postmortem examination because the postmortem examination at that time when I received that call had not been performed.
Meaning the autopsy by Dr. Garavaglia?
Yes.
Oh, wow. Okay. Now we've heard them talk a little bit about this, I believe, earlier on, probably around the time when they were bringing in their forensic pathology. Wow. Okay. So this has come up, I've just in other trials too, right? Where it's this whole thing of like, a great example, right? Karen Reed just recently, right? Talking about the telemetry and what are they doing? They're re-examining the black box of the Lexus. And so they have to do a chip on, right? And all that whole thing. And this whole thing of like the courtesy, if you allow the defense expert to be there. So for any of you guys who are familiar with that, that was from one of the first hearings, I believe, since they brought on Hank Brennan as the special prosecutor. And one of the reasons that myself and others were impressed with him was because he said that he would allow them to be there. And that's not a requirement, but it is a good courtesy, right? To establish like good faith, but it's not a requirement. And so having said that it is probably more on the rare side, right? Where you've got a situation like this, where when it comes to an expert being present for something else another expert is doing, when it comes to the autopsy, because usually what do we hear, right? That you have the medical examiner, or the forensic pathologist, whoever does the initial autopsy. And then whenever the defense has an expert, we always hear that they didn't examine the actual body, because of course not, right? They couldn't, because usually, right, there's not a suspect or there's not an arrest made, and then they have to obtain counsel, and then, right, in other words, it's going to be months and months, if not years on down the line, when a defense expert would get involved. And of course, the autopsy is long. So this is unusual because of a couple things. A, they were able to obtain this expert quick enough, right? Interesting. To where the autopsy hadn't actually been done. That's a really unique situation. So they actually had the potential to have an expert be present for the autopsy. Wow, I don't think I've ever heard of that happening in a case. Because you'd have to be a case where it would have to be a case where there's somebody who's already a suspect and who's already been charged, but the body hasn't been found yet. And then also that suspect has already obtained counsel, and that the counsel has already obtained an expert. And that's a lot of things. Wow.
That's correct.
Did you request that you be
I wonder if they're going to, I'm so excited. Did they let him go? Did they let him attend or not?
allowed to be in attendance?
Objection, Your Honor. May we approach?
Oh boy.
May.
Oh boy. Wow.
You may proceed.
I think the last question was, sir, did you request to attend the autopsy that Dr. Garavaglia on?
Yes, I did.
Were you allowed to?
No, I was denied.
Oh my God.
Why did you want to?
Well, because first of all, it's useful
Wow.
to have.
That's not good. That's not good. That's not good. Because this dude the jury's got to love this dude, right? Like I said, they don't have to, right? But this right here is a great example of why you would want to. Because, especially when it comes to something like the autopsy, again, this is something that doesn't ever happen, but like that's so important, right? And when what you've got is undetermined, right? And then you've got this highly qualified. In other words, if I was on this jury, what I would be thinking is, you know what? Are you telling me that the state who is supposed to be seeking justice said they had the opportunity to potentially actually be able to give an actual cause of death for this victim, and they chose not to? Because that's what this looks like. And the other thing, right, is like, again, usually you'll see the state saying, oh, you didn't actually examine the body. And they use that as a thing of like, well, ours actually examined the body and you didn't, right? When it's like they wouldn't have had the opportunity. I mean, they can't make that they can't go that route now, right? The state on cross, because they, obviously. But wow, like that does not look good. Now, if this dude was not so highly qualified, it would be a different situation.
Seen the body in the
or also, I would say it would also sit differently for me if there was a clear-cut cause and manner of death for the victim, right? But even if there wasn't, if you've got somebody who's this qualified, but again, it's just looking, because of the fact that it was just like Dr. G's entire thing was based on Casey's behavior. That was it. And that's why I was so pissed, because it's like she got nothing. She didn't even talk about the body.
the condition that it was at that particular time, so that I have the same exposure to the body as the pathologist who is performing the autopsy in his or her official capacity. But in addition to that, there is an advantage in having two people of the same specialty look things over together, because 4 eyes see more than 2 eyes.
Absolutely.
And I'm able to discuss the...
Absolutely. And that's the thing, is like they could have gotten to the truth. They could have gotten more information at the very least, right? And maybe he would have come up with the same findings, right? But at least it would, in that case, that would be a good thing for the state, wouldn't it, right? Because it would support, like, I mean, think of it that way, right? If you were the state and you were really sure that 100% in those findings, like it's going to be undetermined, blah, like, then it would work in your favor to have another expert like this be able to say, yep, I also found the same thing. Check, right? Wow.
The findings on and in the body at the time that the body is there in front of us. This is custom in forensic pathology. It is custom in pathology. It is custom that even in a hospital setting, pathologists will send specimens from patients to other pathologists to see if...
Excuse me, sir. Objection, Your Honor. Not a response to the question and relevance of the habits of medical pathologist.
Overruled.
It is customary that pathologists will send specimens from patients, dead or alive, to other pathologists across the country, sometimes across the world, to see if they concur or if they have ideas about this condition or that condition, because those ideas feature in the treatment that is afforded such patients. Maybe life-saving. In a dead person,
he's making a great point.
There is no life-saving, but
he's making a great point. He's like, if when you talk about live people, right, you can always get a second opinion. He's making a great point. Right? While there's no life saving, right, with a dead person, you always get a second opinion from.
There's the question of what else can be done to make a reasonable diagnosis that conforms to all the facts of the case. And that was denied. So,
Thereafter, sir, did you conduct a second autopsy?
I did. When the official autopsy was terminated, I was given access to the remains, and I conducted such autopsy at the Bryant Funeral Home and Cremation Service, or I don't know, it's got a longer name, located in Orlando, and I was able to perform that autopsy at that place.
If you recall, sir, had Dr. Garavaglia completed her report of autopsy before you conducted the second one?
I don't really recall. I don't think so, that she had completed. I don't think she had completed her report.
When you conducted the autopsy, what, if any, first observations did you make that were remarkable to you?
Well, I came here to Orlando, equipped with all kinds of equipment to perform an autopsy, but I did not bring a saw, because I was absolutely certain that this autopsy had been completely done. But when I came and I looked at the body, it had not been completely done.
What had not been done, sir?
Oh my God, don't tell me what? Okay. He said he didn't bring a saw. It was kind of hard to understand him. And I was like, at first I'm like, what was, you didn't bring a saw? Oh, let's listen to that again. You've got, I mean, as horrifying as it is to think about, right? It goes without saying, right? Like, you know that part of what they do in an autopsy is they cut the body open. You've got to be kidding me. Don't even tell, and honestly, it makes sense, doesn't it? What was I just saying? She didn't talk about the body. She didn't talk about findings in the body. She talked about Casey's behavior. Fuck. Oh my God. You've got to be kidding me. Oh my God. I mean, I was going to say, she didn't talk about anything that she did. Like, she didn't even say what she observed. That entire testimony was so messed up, in my opinion. And it was not, but now it makes sense, right? Because if she didn't actually do a full autopsy, I mean, I wonder, it makes me kind of wonder, did she even do an autopsy at all, right? Wow. Okay, let me rewind this. That is, wow.
Did you make that were remarkable to you?
Well, I came here to Orlando, equipped with all kinds of equipment to perform an autopsy, but I did not bring a saw because I was absolutely certain that.
I just, when you think it can't get any crazier in this case, right? For everybody who, like, again, we've talked about it before with this coverage, like, of what the general consensus is and all the misconceptions and all the things that people think, and literally every single one of them is factually not correct if you actually watch the trial. And so, and people that still to this day everywhere go around saying Casey Anthony's guilty, blah, blah. I mean, one thing that should shock people, even if that's what they think, right? One thing that should shock people to know is, like, hey, did you know that the medical examiner didn't do a full autopsy? Like, right there, that should be concerning, right? Just to people.
This autopsy had been completely done. But when I came...
And that's before even getting to his findings. And if his findings say it could have been drowning, then, that's but even without that, though, right? Just the fact that there was not a complete autopsy done from them, is insane. I
looked at the body. It had not been completely done.
What had not been done, sir, that you believe should have been done?
Well, it's not that I believe, but I think the profession dictates that when an autopsy is done and done the way it should be done, there should be an examination of the interior of the head, and that was not done because the skull had not been opened.
And did you, sir, open the skull and examine it as a forensic pathologist?
I did.
May I approach the witness, Your Honor?
You may.
Wow.
You open the bag and take the contents out, sir?
I'm sorry, I couldn't hear.
Open the bag and take the contents out.
Skull, not the skull of this deceased.
Oh,
this is a skull of an adult human being.
Oh my God, this is freaking amazing. He's got a plastic skull. We're going to learn. We are going to learn from, like, the most qualified person ever. Awesome.
Not
awesome.
A plastic or fake material. This is bone.
Love
and
it.
I brought this because I thought it necessary that the trier of fact observe what...
Not responsive and narrative.
Shut up, Mr. Ashton.
Sustain. Let's get a question.
Doctor, would you demonstrate, sir, what you mean by opening the skull, the protocol that you say Dr. Garavella did not do?
When a skull is opened, it is opened like I'm opening the skull now. So in other words, a saw is used to saw the skull all the way around and to remove the cap, as it is called, and look at the interior of the skull like I'm showing here and like I'm showing here. This is the outside, this is the inside.
And at the autopsy,
this is the outside, this is the inside.
Dr. Spitz, during the autopsy, were photographs taken, sir?
I'm sorry?
You take photographs?
I did. I did.
Yeah, approach the
You may.
Don't worry, we won't see anything graphic.
Exhibit BY for identification?
Yes.
Does that photograph fairly accurately portray the appearance of the skull after opened by you for the second autopsy?
Yes, it was. It is. I'm sorry. It is.
Opposition evidence, defense extra. I'll give you a copy of it. Right?
Okay. It will be received in evidence as defense exhibit numbered.
It looks like she might feel kind of sick.
With the court's permission, we have it.
Blame her.
And in part, photograph.
Oh, no, there's a picture. Yeah. Okay. Yeah.
You may.
Now I don't know. They probably won't show us.
And with the court's permission, may I have Dr. Spitz step down
Yeah, but make sure we put a microphone on
for me?
for both of you. Doctor, you may step down, sir.
Thank you.
So I think so. They're presenting this to the jury, and so what happened was he picked it up and was carrying it, and then she caught a glimpse of it. But now, as we've seen them present all the other things to the jury, it's facing the jury. So not, in other words, the back of that poster would be, that's what she would be seeing. And so she can't see it anymore. And probably in the gallery, you can't see it unless you're sitting in a certain place. Given the way the courtroom is laid out.
As I think we're probably going to go for it.
Okay, so now she's blocking her. Okay, maybe they did put it up on a screen then.
Mr. Mason, Mr. Mason, can you switch places? You'll be over there.
Oh, I'm sorry.
That'd be better if he stands over there.
Over the side?
Yeah.
Okay.
Thank you.
I'll stand behind you. I think they can hear me. I will.
They must
Dr. Spitz, is that the enlargement?
I can't see. If you
Position yourself, Mr.
I'm trying to get.
I know, but he has to be able to communicate with his witness, so. Go ahead.
Thank you, sir. This photograph enlarged here is the enlargement of the one that you took during the autopsy.
Yes.
Would you tell the court and the ladies and gentlemen of the jury what, if anything, is remarkable about the contents of the photograph that we have before them?
Well, this is what it represents the base of the skull, the bottom of this box. The lid is here, taken off by sewing all the way around. This is what you then would see if you look into the box. And this is where the vertebral column, the spine connects, and the spinal cord goes in here and into the brain. And this is the front. This is the back. Actually, it should be reversed. Do you want to do it with me?
Do it the right way.
Well,
So now they gotta flip it over.
I got it.
yeah, this is better.
Teamwork.
So this is the front, this is the back, this is the right side, this is the left side. And this is the reverse. That means this is the left side, because if you flip it over, then this part would go onto here. And what you see here is in this area, which is the left side of the skull, the base of the skull, you see black flecks.
Mm-hmm.
These black flecks are material which represent the last and permanent result of decomposition. What that means is that the brain, which fills this entire space, is gone. The brain has dissolved. But some parts like iron, magnesium, phosphate, sodium, chloride, all kinds of elements like that remain permanently. They don't disappear. This is ashes to ashes and dust to dust, what you read in the Bible. And this is the dust which is remaining. And this amount of dust would have been probably just less than an ounce. But of course here, there's no 1 ounce because some of this dust has been removed, has gone, I don't know, lost. And could have been, it could have been water, there could have been whatever, anyway, it's lost. These specks are attached to, they came down and they just remained. And they indicate the position of this skull over the decomposition process.
Okay, that's
decomposition process takes time, quite a lot of time, to end up in just this representing the specks to be left over after the entire brain has gone. So this indicates the brain has disappeared and those elements sunk 2 by gravity to that place.
So I just wanted to know, this is really interesting because essentially what he's saying is by doing a full autopsy, which Dr. G did not do, right? And by cutting open the head, looking at this stuff, right? As horrifying as it is to think about, it's not just it's going to tell us more than just cause and manner of death potentially, right? But that's so important. What he just mentioned is that by looking at this thing with the brain, as he's describing, you can tell the position that the head was in during decomposition. And wow, that's so important. I mean, and it wasn't done by Dr. G, obviously. But I'm really curious to see what we're going to learn because, of course, this is a huge point of contention.
And very little by little by little, over months, this has occurred. And it tells you the position of the skull.
What was the position of the skull?
The skull was positioned in a left side of the skull down. That means if this is the ground, the skull would have been something like this.
Show the jury with our friend here, sir. The position it would have been throughout the decomposition.
Well, here is the base of the skull. This and that are the same. And the specks are localized in this area on the left side. And the skull would have been like this, positioned like this. This would have been the position of the skull. Maybe with the face a little bit up because it seems to be somewhat more to the back. So maybe a little bit like this.
All right, thank you, sir. If you can let me turn up there. Has the jury had enough time to look at this? Dr. Spitz, did you review the records and documents contained in Dr. Garavalia's report of autopsy?
I did.
What, if any, problems did you detect?
Well,
I'm sorry.
Yeah.
Oh, dear.
What, if any, problems did you detect, sir, or deficiencies in her report?
Objection to the question of relevancy of deficiencies in reports that weren't testified to in this case and aren't an issue.
What the fuck? Mr. Ashton, sit down.
I examined the entire skeleton.
Which she didn't.
There was very little, if anything, any bones missing. And if there were, there would be little bones.
Okay. Right.
Little parts, but most by far of the skeleton was available to be examined. The skull had not been opened, so I opened it and I showed the jury what I saw, what I found. There are certain things I did not find, which could have been there, but I did not find that they were. Like, for instance, some discoloration of certain parts of the skull, like the place where the ear is, the mechanism of the ear, the little protrusion of bone in back of the lower jaw to the side here, on the side of the skull, and the mechanism of the ear, which is at the base, which is inside here and there. There could have been some discoloration, which I did not see. There were no fractures, no blows that I could identify on the skull. The skull was intact, in other words, undamaged. There was some damage to some bones, some long bones, meaning arms and legs, and other longer bones, which was due to post-mortem, meaning after death, predation by animals, meaning where animals find bones with some flesh on them and they go ahead and chew on those parts. That I found. But other than that, there was no damage. There was an area of one of the longer bones of the thigh, because the thigh is a fairly long bone in a child, 3 years old, probably around 5 inches maybe, and that had been opened by those who did the first autopsy. I surmised that they would do, when I saw that had been opened, I thought, well, they probably opened it in order to take specimens from the bone marrow.
Let me object to the narrative. I think we've gone away from the question that was answered.
I thought that they had done this, opened the bone to get access to the bone marrow, to the bone marrow cavity, for the purpose of removing certain material that would be helpful in diagnosis. But I subsequently learned that had not been the case. So based on this examination, the cause of death remained unknown for those who did the first autopsy, and for me to some extent as well.
To some extent.
You recall reading Dr. Garavalia's statement references to duct tape.
I understand that there were some sections of duct tape on the lower face that were loosely on the face, but since there was, I should say, there was not a shred. I've not said that before. Not a shred of soft tissue. No skin, no muscle, no fat, no nerves, no blood vessels, no nothing. So much so that when I came to Orlando to handle this, I brought a whole bunch of gloves. I bought an apron. I bought to protect myself from possible contamination. I used nothing because the skeleton that I received was in this condition. And like I touch this now without gloves, without apron, that's how I
So he's handling that plastic skull.
touch the other one. This is totally clean, and there's no bacteria, no nothing to contaminate me from handling this. Just as little as there was to be contaminated, to be infected, or to not allowing me to handle those remains of this 3-year-old child. Consequently, I did not need any of the material that I brought. The tape was not there when I got the remains. The tape on pictures shows being to the side of the lower face, somewhere here on the left side, on the right side, if I remember correctly, hanging.
The photographs speak for themselves. The jury has seen them, can interpret them for themselves.
Overall, hanging on hair and hanging on roots of vegetation of the area that had in the period where this was sort of in an excavated, in a little lower, partially under the surface of the ground. Vegetation had grown into this material. Plants benefit from the minerals and chemistry that is generated by decomposition.
Dr. Spitz, in the report from Dr. Cavallias, he indicated that the duct tape was clearly placed prior to decomposition. What, if any, opinion do you have regarding that assertion, sir?
Well, I have some problem with that. Because when duct tape is applied to the skin.
So this black square, I'm not doing that. That's court TV. It seems like they're trying to redact that skull, which initially they didn't, which is really funny because it's that plastic skull. So I don't know if like this was a mistake done by like AI or whatever, because it doesn't need to be redacted. It's the first time I've seen it in this case or on anything of court TV. It's just funny. So it's like maybe if they had a program that's supposed to identify things and it thought it was supposed to redact the skull. Anyway, that's all it is, because sometimes it kind of like doesn't time it correctly. So if you see that black square, just know that it's because that plastic skull is there.
And the skin decomposes. The duct tape just doesn't go anywhere. The duct tape doesn't do anything. The duct tape becomes loose on the skeletal structure, in this case the face. The only thing that held the duct tape there was the roots and the hair that originally, I don't know in what fashion the duct tape came in contact with this. There was no duct. There was nothing on the bone that would suggest duct tape. There was nothing on the duct tape that would suggest the application on the skin either. So I have some difficulty with identifying when this duct tape was placed, other than to say that it is my strong feeling and opinion that this duct tape was perhaps placed there to hold the lower jaw in place, because if the head is subjected to as complete a decomposition as it did, where there is absolutely no trace of flesh on this head or in this head, if I would have picked this up like this,
he's holding the skull.
The lower jaw would have dropped, just like I'm going to show you.
And this is what we've already heard even from the state's people. They said, the forensic anthropologist, one of them said, it was weird that the jaw was in place because no one expected that. And the reason is because the duct tape was underneath that area, right? So what he's saying makes sense. So in other words, because the adhesive on the tape is all gone or whatever, right? Like, in other words, what he's saying makes sense, which is that that tape would have been maybe put there post-mortem, right, to hold the jaw in place. And then over time, the adhesive dissolved, but it was on there long enough to keep it in place. I think it's
because this lower jaw is attached by, this would be like this. That's how, well, or like that.
I wish they would be showing us.
I would touch this to remove it and note what happens.
There you go.
The lower jaw falls down. So, being that it fell down, if the duct tape was attached to the skull, it would have been held somewhat by the roots and maybe by the fact that there was hair between the duct tape and the lower jaw.
And sir, would you have expected there to be DNA on the duct tape if in fact it had been placed over the face?
I would have expected DNA, yes.
Of course.
And would that be true whether it was placed?
I mean, if this was the duct tape was attached to the face, there would have been DNA from the face on the duct tape. I put duct tape on my arm, and when I removed it, I pulled out hair, sometimes with roots, from my arm on the duct tape.
And based on
and there's no doubt in my mind that if you would have had duct tape on the skin, there would have been some evidence of the presence of that skin DNA on that duct tape.
And that's the thing, right? There was no DNA except for on accident from the analyst at the FBI, right? So I wonder if what he's actually saying then is like the tape somehow got on there at some point, even after there was nothing left but bone, maybe, which is interesting.
and
For
through
the simple reason that there is a firm connection between the duct tape and the skin, to the point where decomposition is always less in an area of pressure against something, against a wall, against pieces of clothing that are tight. The decomposition is less in those areas where there's no air coming in, because bacteria also need to live, and bacteria are what cause decomposition.
Okay. That's a very interesting point that he's making. What he's saying is like, if that tape had been put on there, right, from the very beginning, and I guess where it was touching skin, right, touching flesh, that the other thing you would have seen is a difference in how that one portion of the face or whatever would have decomposed because of the pressure from the duct tape and it not allowing bacteria. That's really interesting. Huh.
All right. And then is it your opinion, sir, that the tape was not put on the face before decomposition, even antemortem?
No, it was not. I think that the duct tape was a later event, not an early event.
After decomposition?
After decomposition.
Wow.
Sir, tell the ladies and gentlemen of the jury what the term adipocere means.
Adipocere is a stage in decomposition when the tissue becomes broken down,
The jury
slimy,
knows, but
smelly. You'll have to excuse me, the comparison, but that is the comparison we pathologists use to compare. We are not always very elegant in our descriptions. We call it soapy. It's like soap. It's like soap. Adipocere is like soap. It is a special, especially fat undergoes adipocere. That is like soap, broken down to a consistency that is similar to wet soap.
Do you have an opinion, sir, as to how long it takes for adipocere to develop?
Adipocere develops at...
Can we approach?
huh?
You may proceed.
You're ruling? The question to you, sir, was how long does it take for adipocere to develop?
Adipocere under optimal conditions, that means under conditions of warm environment, will begin to develop such that we can call it adipocere within like 10 or 12 days.
Did you find, sir, the apparent presence of any adipocere?
Oh, no, absolutely not. There was, like I said, there is no more soft tissue on that skull like on this skull, compared to this skull.
Based on your review of Dr. Gavalier's report, folks, hold on a second. You reviewed the whole thing.
I'm sorry?
You reviewed all of Dr. Gavalier's report,
Yes,
including the toxicology report,
including the toxicology,
the anthropology report.
anthropology.
Were you able to determine, sir, if there is any evidence as to the cause of death in this case?
Oh boy.
Well, there are, you can rule out certain causes of death, but you cannot answer the definitive question as what this person, this child, really died from. She could have died of certain conditions that at this point we don't see. But you cannot rule out all conditions, but you can rule out some. You could, for example, rule out that there was a skull fracture. There was no skull fracture.
And as a medical examiner, would you also reasonably rule out one of the other four, like suicide?
Oh, yeah, I would rule out suicide.
Can you, from the evidence, sir, rule out accidental death?
No.
Now, there's a difference between cause of death and manner of death, correct?
Yes.
What, if any, opinion do you have, sir, as to the manner of death in this case?
The manner of death means, like I said already, natural causes, accident, suicide, homicide, and natural causes.
Interesting.
There are 4 classifications for manner of death. Cause of death is something else. Cause of death is pneumonia, gunshot wound, lots of causes of death. But manner of death, there are only 4. Homicide, suicide, natural causes.
I'm really curious what he's going to say about this. This isn't usually asked of a defense pathologist because oftentimes the homicide part's not really in dispute. So that's why this is really, I'm like surprised. I'm like, wow, this is the fact that he's asking this question makes me think he's going to say something other than homicide or say you can't say definitively.
So,
in this case, do you know what the manner of death is?
The manner of death, I would not be able to
Determined.
tell you. Based on the exam.
And that makes sense, right? Because remember what Dr. G came up with was cause of death undetermined, manner of death, homicide by undetermined means. And then when asked again further, it's like, well, where did you get the homicide part? Oh, I got the homicide part because of Casey's behavior, but had nothing to do with the autopsy. So it makes way more sense. And it just logically, right? And it's funny because you don't usually hear homicide by undetermined means. You usually hear just homicide. That's why I thought it was interesting at the time that she actually added that in. And I wonder if she added that in because to try to thwart, get out ahead of the fact that it's going to come out, right? That undetermined from this expert. But that's the only thing that makes sense, right? Like, so.
Examination as it stands today, I could not tell you what the manner of death is.
Now, sir, finally, do you know approximately how many autopsies you have conducted in your career?
Well, I guess at this juncture, I was wrong about the thought of, was he going to be able to say something about drowning? But I will say one thing too, that we've learned a lot from this expert. One thing that I think is helpful is I don't know that we really got such a good picture of the condition of the body. It wasn't really clear to me until he brought in that plastic skull, right? Like the Halloween skull, right? And it's like, this is literally what the body, like, it's like, oh, okay, right? Because like, at least for me, it's hard, and one doesn't want to imagine, right, what is going on with the decomposition. But anyway, in other words, I don't think it was made so clearly until he explained that you didn't even need gloves. Like it was completely the same as that plastic skull. So, so that knowing with that, like knowing that and having that as made way more clear, it would make sense that there would be no way to determine had I known that before, then it would have been really obvious that there would be no way to determine if drowning was involved or not, right? Because there's literally no way from just bones. But that wasn't really that obvious, that wasn't made that clear. So, yeah.
Around the world.
I have either conducted or supervised the residents doing autopsies on approximately a total of 60,000.
It would have been possible to do the drowning thing.
I have no further questions.
I've been practicing forensic pathology for 56 years.
Hang on just one second, please.
I'm curious, what are they going to do for cross, though?
No further questions. Thank you very much.
Okay.
We'll take a 10-minute recess before we proceed with cross-examination.
Perfect. We'll have you look at the screen in a minute for right now.
Cross-examination.
Doctor, if you could kind of turn that screen a little bit, because I can't really see you down there. Thank you. That's perfect. We'll have you look at the screen in a minute for right now. That's great. Doctor, a medical legal investigation, particularly in determining manner of death, requires consideration of information outside of merely the medical evaluation of the remains.
Oh my God. Of course. I should have known. I should have been able to answer that question. The question I just asked is, what is he going to do for cross? Of course. He is going to try. Wow. Really? He's going to try to use this expert to support the fact that Dr. G based her autopsy findings from her testimony, from her testimony, it was entirely based on Casey's behavior, and that was it. But he's gonna have to work his way into it by starting with like things that would actually make sense. Like you can use other things besides blah blah, right? And it's like something that would actually make sense. Because if he just came out and said by assessing somebody else's behavior, it'd be like, are you joking me? Anyway, that's the angle there. He's wow. Okay. There you go.
What information about
Because then that's the thing, right? He has to stay away from the body. Stay away from the body. That's the whole thing for the state. Stay away from the physical evidence because it doesn't point to their theory.
this case, that is the investigation of this case, were you given in order for you to render the opinion you rendered on direct examination?
Well, I was given information of the first autopsy, whatever is included in.
You know what he's going to get to, I bet, is you weren't given information about how Casey was behaving or whatever Casey, the lies. I mean, again, if you go that route, if I was the defense, I would come back on redirect and go ahead and bring in the parents, right? Talk about lying and odd suspicious behavior and false statements and literally everything else. And again, as I've said a million times, there's actually way more evidence that connects George to this than Casey.
That autopsy report. I was given information. I was permitted to go to the scene of where the body was found. I went to the house as well, to the house where the people that have an input into this case resided.
The Anthony home.
The Anthony home.
Okay.
Interesting.
I was.
Who had input?
Well, that's about it.
Well, but in order to do an adequate medical legal investigation involving manner of death, you need to know the surrounding circumstances revealed by the investigation, not just the medical aspects, but the entire background.
I understand that. And I asked questions of those who know about the case. I asked to give me information that I wanted to have, and I received that information. I cannot tell you now each and every question that I asked, but I asked sufficient questions to allow me to have a good idea about what I think happened here.
Who did you ask?
I asked, well, Mr. Baez asked. I asked Mr. Mason. I asked, well, I think I spoke, if I'm not mistaken, I spoke to the people in the home, some of them that I met over there.
Who did you speak to? Did you speak to the Anthonys?
In the Anthony home. I don't remember who those people were.
Did you read any of the police reports?
I did have police reports, yes.
Oh, okay. Well, you hadn't mentioned that. Tell me about the police report.
That's right. I had those too.
Which ones?
I couldn't tell you. I didn't know that they were.
Tell us what your understanding of the predicating facts of this case are leading up to the finding of the body. What is your understanding? Those facts that you used in your testimony, your determination and opinion you gave to Mr. Mason on direct.
Well, I understand that there was some time, a lapse of
sad. This is sad, right?
Time of a month between the disappearance of the child and when a police report was made.
Now, aren't the facts of the last time anyone saw a victim always extremely important in a medical legal investigation?
Yes, everything needs to be evaluated together.
But the last person who saw her was George Anthony.
Not independently. That's why everything has to be fitting together like a jigsaw puzzle.
So I'm sorry, you done?
I'm sorry?
I just want to make sure you're done with your answer. You pause. I want to make sure that you're done before I go on.
It all needs to fit together. You cannot take one item by itself, but you have to evaluate the entirety of the picture.
What is your understanding of the events of the last time that Caylee Marie Anthony was seen alive?
Incredible.
Would you ask me that again?
Sure.
I just want to reiterate. This is a forensic pathologist who does autopsies, and listen to the questions that are being asked of him. I've never, and I doubt ever will again, see this in a trial. I mean, have you guys, this is insane.
What's your understanding of the events?
It sounds like questions you would ask somebody who's like a social worker or maybe a forensic psychologist or law enforcement, detective. Of
the last time Caylee Marie Anthony, that's the victim in this case, was seen alive.
I know that Caylee Anthony was allegedly taken to a babysitter. That's what you mean? That's my understanding that's something that occurred when she was.
I just want the jury to know what information you had about the background of this case, which you acknowledge is essential in coming to the opinion that the manner of death is undetermined, as you expressed to Mr. Mason on direct. I want the jury to know what facts you had in making that decision. So please explain that to us.
I don't know that I had any facts on when she was alive. I cannot recall information that I had that allows me to recite for you what she was doing or what was happening to her when she was alive.
Well, then, would you not agree that Dr. Garavaglia had considerably more information than you do in coming to her opinion that the manner of death is homicide by undetermined means?
Well, if she knew that information, I'm aware of whatever she put into her report. And that's a fairly lengthy report if you consider all the anthropology and toxicology and microscopy and whatever else is in that report.
That's a good answer, because in other words, if she knew it and it was actually used for her to make her opinion for her findings, it would be in her autopsy report, right? If her if indeed the behavior of the mother and whatever, like what she testified to, if that was what she used to come up with her autopsy findings, as odd as that sounds, that would be in the report, and he read the report. So that's a good point.
But I do not recall any information that she had that I did not have because I read her report.
Yeah.
Well, but
so if you tell me that she wrote something in that report that I did not tell you, then well, I had that information and I would have read it. So I would have been aware of whatever that she wrote in her report. I was totally familiar with.
What did she write in her report about the predication of this? The last time she was alive, what did she say in that report? Do you recall?
What she said?
What Dr. Garavaglia said?
No, I don't recall.
But it is common in forensic pathological reports to summarize relatively briefly the facts of the investigation, correct? It's not generally a practice to put in every single fact that you may have learned, but rather to...
He's trying to get ahead of what I just said, right? In other words, it's disgusting. Wow. Like, oh, she didn't have to include all of it.
Summarize them.
Well, some people do and some people don't. I don't, but many people do.
But to do a complete medical legal investigation, one must look to all possible sources of information. At the very least, read the police reports and statements of witnesses.
What this is really getting to, I wonder if this is going to come up for the defense. What this is really getting to then is like that Dr. Garavaglia, essentially then gave opinions when she testified, right, as to the cause and manner of death that were not in her autopsy, is what it sounds like to me.
To determine exactly what led up to this child dying. That's essential, isn't it?
Yes, and therefore we do read police reports.
But you've just told us that you don't remember any of the facts of this case or what happened.
I didn't tell you. That is not,
Okay.
Yeah,
I don't think that's correct.
What do you
Paraphrasing what I said. I did not say that I don't recall any of the facts. I do recall facts that I considered significant for me to.
And actually what happened was he asked for a clarification question because he was like, the question was so general and Mr. Ashton never provided one.
Formulate an opinion. And you asked me what I knew about Casey Anthony before she disappeared, before she was when she was last seen alive. And that I do not recall. All I recall is that she was a healthy young 3-year-old child.
Well, let me ask you this way, to be fair. What do you recall about the facts leading up to her disappearance or death that you considered significant in coming to the opinion you expressed on direct?
Not when she was before she was last seen alive.
Well, if you did not consider that fact significant, that's fine. But tell us what facts you considered significant about the time leading up to her death or disappearance that you felt were significant.
Well, I thought that there was a pool in the house, in the yard, which I saw when I was there, which creates a possibility of drowning.
Beautiful.
I understand that for a month went by without informing the authorities that the child is missing.
Do you recall any other facts of significance?
Oh my God, he's mad. That's really funny. Well, he has.
No, I don't recall other facts. If you want to remind me of them, I'll be glad to listen.
I'm just inquiring of the ones that you felt were significant in rendering the opinion that you gave to Mr. Mason on direct, and those are the facts that you found significant.
Yes, and that is a fact that I understand that she was missing for a month.
Now, you also indicated in direct examination that the failure of Dr. Garavaglia to open the skull was a violation of protocol.
Correct.
What protocol is that?
The protocol is that we have here an autopsy on a child that has was the ultimate examination by a forensic pathologist in a case that had made national news. We open the head in.
Your objection, non-responsive. The question was what protocol was violated.
Doctor, do you understand the question?
Yes, I understand the question, Your Honor.
Okay. So what protocol was violated?
The protocol is that the head is opened in any individual where there is a possible involvement of the skull, the meninges, the brain, and any structure that would theoretically benefit from a skull examination, from an opening of the skull. Let me say this, that the skull, the head, is part of the body. And when you do an autopsy, you examine the whole body.
I think what the problem, I mean, and this is, all this is true. I think that what Mr. Ashton will then say something or ask something like, is it's up to the forensic pathologist's discretion. Then it's not required. Maybe
that's just like when you buy a house, you buy a whole house, not a house without a basement. If you want to have a house without a basement, maybe you can find one. But in general, you buy a whole entity, and that contains a living room, a dining room, a bedroom, with this kind of stuff. And it's a complete structure. The body is a complete structure. The head is an extremely important item in all this.
Kidding.
There can be all kinds of things in a head that occur that you need to know about. You mean to say that I examine only from the head down? The rest is of no significance?
Yeah, no, I mean, that is crazy.
What I'm asking you is, where is this protocol published?
There is no publication. This is part of the.
Right. There it is.
I don't know where that is published, but I do know that I have been trained, and I have trained lots of medical examiners to practice forensic pathology. And there is somewhere that I'm aware of, because I was a member of the committee that made that document, that what we should examine. But I don't know what that's called. I've been out of the mainstream of.
Okay. So they need to see if they can take a break and find that document.
Administrative forensic pathology for some time now. But to not open the head, I think, is a failure of the autopsy. And I'll tell you another thing, that if an autopsy was done in a corresponding to what I think every forensic pathologist will tell you, where the head is not opened, that tells me about a shoddy autopsy. Ooh. Excuse me the expression, but you provoked it. A shoddy autopsy, because if the head is not opened, what else wasn't examined?
Right.
Sorry, I apologize. I didn't mean to provoke you.
Yeah, it upsets my better knowledge, my better
I
understanding of my profession that I've now practiced for 56 years, that somebody would do an autopsy.
Let me check. Excuse me, sir.
So here's what I think he's saying. What he's saying is, I'm sure it's published somewhere, but it's so obvious that that's why, like, it's like asking, I feel like we heard some questions like this asked of Dr. Russell in the Karen Reed case with the Daubert hearing, which I haven't covered yet, but where it's like something that's so obvious that it wouldn't need to be put into a list of protocols, right? So like, that's why he's getting so offended, because it's like, how can you not examine the head? Like, the only reason you wouldn't examine the head is if you don't have the head, right? And that's why he's saying that, like, I think the question is offensive, because it's like asking him to prove or, support something that is just so obvious and common sense and goes without saying. I think that's what's going on here. I'm trying to think of like an analogy of like, I don't know. Again, there were a lot of questions I feel like asked of Dr. Russell on cross exam that were that would have fit into this category of like these questions that were just so dumb. But anyway, I can't think of anything off the top of my head.
I would object to the narrative and not responsive to the question.
Let's have another question.
Thank you. So a skull is opened in an traditional autopsy of a non-skeletonized remains in order to examine the brain within the skull and the structures within the skull. Isn't that the reason?
No, that is one reason, but it's not the only reason.
What other reasons are there?
Well, each case beckons a certain examination of certain things within that same location, namely the skull and what else is there. I would never have known how this head was positioned, for example.
Right.
If I didn't open it.
We'll discuss that in a minute. But what I want to establish is there's also a protocol for autopsy that requires the opening of the chest by, is it cutting the ribs along the sternum?
Well, you're not going to get access to the chest organ if you're not going to open the ribs, just as little as you're going to have access to the brain if you're not going to open the head.
So certain protocols that apply to non-skeletonized remains don't apply to skeletonized remains because you can see what's in there because everything else is gone, correct?
No. You mean you can look inside the head without opening it?
I already know that's exactly right. He was trying to compare it to ribs. Are you joking me? He was trying to compare it to with a body that's not fully decomposed, right? If you want to see what's inside where the ribs are, you'd have to cut it open. And whereas if it's a skeleton, you can see it. And that was a dumb, that question was so dumb. Let's listen again. Because yeah, inside the head, are you joking? Oh my
Just to the
God.
brain if you're not going to open the head.
So certain protocols that apply to non-skeletonized remains don't apply to skeletonized remains because you can see what's in there because everything else is gone, correct?
Not the head,
No.
obviously.
You mean you can look inside the head without opening it?
Yeah.
Well, you have to show me how to do that.
There's a little hole right in the bottom.
I'm sorry?
Isn't there a little hole right in the bottom?
I'm sorry, I don't understand.
I'm sorry, I'll withdraw the question. Now,
Just being
are
a
you
dick.
aware of
Oh
any,
my God.
you're aware of this book, correct?
Yes, somewhat, yes.
Well, you
mean,
edited it and wrote some of it.
Exactly.
And this is a compilation of
And by
articles
the way,
on,
Mr. Ashton was referring to the mouth there, but which was a dumbass, snarky question. But beyond that, are you really saying that that's sufficient, right? To see inside what's inside the entire skull now.
virtually every subject in the area of medical legal investigation of death. Isn't that correct?
Well, it is a,
Medical legal investigation of death by Spitz and Fisher, the same book that Mr. Mason asked about a moment ago.
It is a textbook in forensic pathology.
And it contains articles on virtually every aspect of medical legal investigation. Some of them you wrote yourself. Is that correct?
Yeah, I wrote most of the trauma chapters.
There's chapters on forensic anthropology.
Yes.
And those are written by William Vass, whose name we've heard a number of times in this case. There's articles on forensic entomology.
Yes.
Written by Neil Haskell. Correct?
Correct.
Now,
It's a statement at this point. If you're going to use an authoritative.
would you agree that this is an authoritative treatise on the medical legal investigation of death?
Yes.
May I approach the witness?
Yes.
That question was because it's hearsay unless they get that in. That's an elite.
Where
treatise.
in this book it establishes a protocol that requires the opening of a skull in a skeletal case.
So this is not a book on protocols. This is a book which talks about findings and interpretations of wounds and what happens to a person after death and things of that nature. This is not a book that tells you about how to do an autopsy.
Yeah.
It tells you how to interpret injuries. And you will find by reading this book that the head is opened in just about every type of autopsy one performs, because it shows you injuries in the head. And to find those injuries, you need to open the head.
And in the chapter on forensic anthropology written by William Vass, does it contain a protocol
Look at him smiling.
that suggests that the skull must be opened in the...
Look at what's going on. These two, hold on. What's going on? Look at this. Look at this. Huh. They're like laughing and smiling.
Injuries in the head. And to find those injuries, you need to open the head.
And in the chapter on forensic anthropology written by William Vass, does it contain a protocol which suggests that the skull must be opened in the...
Overruled.
That
Mr. Mason, you need to repeat your objection. The court reporter did not hear it.
I'm objecting to the prosecutor's efforts in violation of 611 regarding bolstering of his witnesses or attempting to.
Overruled.
the question was the chapter on forensic anthropology in this book that you edited.
Yes.
Does it contain any protocol or requirement that the skull be opened in a skeletal case?
This is not a book on protocols. It probably doesn't say that the head needs to be opened anywhere in this book, because but it does talk about injuries and findings in a head that occurred during lifetime, and in order to find those things, those manifestations, the head needs to be opened. So whereas it doesn't say that go ahead and open the head, it talks about the findings in that head which require the head to be opened.
Now, are you familiar with something called the Minnesota Protocols? It's a UN document. The full title of the document, for counsel's benefit, is Manual on Effective Prevention and Investigation of Extralegal, Arbitrary, and Summary Executions, specifically Section 5, titled Model Protocol for Disinterment and Analysis of Skeletal Remains. Are you familiar with this document?
I know nothing about that. If you can, maybe you can tell me who wrote that.
It indicates it was drafted in consultation with lawyers for the Advocates for Human Rights, formerly the Minnesota Lawyers International Human Rights Committee. This manual, which supplements the principles of effective prevention and investigation of... Well, actually, let me make report and have them read it.
Yes.
You know, this is written by lawyers for lawyers, and as I said, by lawyers. It's written in legalese. I don't understand it. I'm not a lawyer.
Would you
I
read-
have been a lawyer,
Wow.
and I don't know how even to
So that's not by doc.
understand this document.
Would you read the, I think it's 3 or 4 pages in, it's section 5, the model protocol for the,
Objection, Your Honor, is improper effort to impeach with a non-recognized, non-authoritative source.
I'm just trying to determine whether he recognized it, not read it out loud, but read it
He
himself.
doesn't
He's already
recognize
said he
it.
didn't
Yeah.
recognize it.
Sustained, he's indicated he does not recognize it.
Yeah.
Well, I just thought he might, if I may have him just
Stop
himself
it.
review that section 5 to see if he recalls that section as opposed to the lawyer E's part.
Okay, look at that section, Doctor.
Would you show me which section that
Sure.
is?
You might.
No, I've never seen it. I can tell you that.
All right.
Yes.
So, Doctor, it would be fair to say that when you, on direct examination, said that Dr. Caravaglio's failure to open the skull violated protocol, what you really meant was it violated the way you think it should be done, correct?
No,
So there's no written protocol anywhere, correct?
I did not say that. I'm not aware of a protocol, but I can assure you that investigation of the head is part of a complete autopsy. And that we are dealing with a need for a complete autopsy in a in a case of national significance, because this is shown on all televisions and the newspapers, and they all talk about this case. And therefore, wouldn't you think that an autopsy is required to document all the findings and not only those below the head?
Now, you've said that twice, actually pointed out the high-profile nature of this case. That's a significant fact to you, isn't it?
Which one?
The fact that this is a high-profile case of, you said, national significance. That's a significant fact to you, isn't it?
Of course it is significant. It is significant that that the pathologist recognize that this case maybe requires more questions to be answered than somebody 85 who is found dead in bed from heart disease.
So you think that the fact that this is a high-profile case means that it should be done differently than somebody that nobody knows or nobody cares about? Is that what you're telling
No, that's not what I'm saying, sir. There is no case which nobody cares about, because there are always relatives, there are always people who want to know, and there are people in this case that want to know. And they not only the people in the family want to know, but the police want to know, and the people in the street want to know. That's why the television broadcasts it. That's why it's high profile. But that's not the only reason why you open the head. You open the head because that belongs into a complete autopsy.
How many media interviews have you given about this case since you were hired? How many?
I have given one interview that was for a local station here in Tampa, in Orlando. And then somebody called me from a local paper in Detroit and asked me about my coming down to Orlando. That's it.
Didn't you do an interview with a Detroit TV station as well? I think it's TV6 out of Detroit this very week.
On which station?
Out of Detroit, your hometown, out of Michigan, I should say, up where you live. Didn't you do an interview that was televised on the local TV station up in Michigan where you're from this week?
That's the one that I mentioned to you. That's the only interview that I gave for television on this case for the local consumption here in Orlando. I gave it in Detroit, but it was broadcast to Orlando, and they broadcast it here in Orlando.
Okay, he's clarifying.
In addition to that, a newspaper learned, the Detroit News learned that I'm coming down to Orlando and called me and asked me when I'm going and what I'm going to do and so on. So that is what the extent of my media response to this case.
Well, you gave an interview to a gentleman by the name of Tony Pipitone. I think he's not here today.
Ask your question, sir.
Certainly. Then you also gave an interview this week to a female reporter for a local station in Detroit, didn't you?
Didn't you?
Yes, I think I did. That was also in response to, I don't think that there were a lot of facts in that case described about, or any facts about this case. There was mostly a logistic that I'm actually going down. There were all kind of other issues discussed in that interview.
You don't recall in that interview with the female reporter for the local station discussing at length your testimony in this case, your theories about brain dust, your theories about tape application? You don't remember
what application?
About tape being applied to the skull? You don't remember
recall that, this was, that's correct. I did talk to her, but I don't remember what I talked to her about, because this was shown and I was meaning to watch it, and then I fell asleep as it was being aired.
Believe me, I can sympathize after this week. But you were also on the Today Show back in June of 2009, were you not? Giving opinions about this case.
I don't recall that.
You recall being featured on 48 Hours on a nationally televised show about this case.
No, I don't remember that.
You like high-profile cases, don't you?
No, I don't like or dislike. I look at a case to render opinions about that case, but whether it's a high-profile case.
I'll just say that this is a case. Oh my God, sorry. It was a terrible pause. This is really hypocritical of the state because, you know, they remember Dr. G was not supposed to be doing their autopsy. It was supposed to be that other dude. I don't remember his name, but he seemed great. And she was out of town. Right. And remember, it was a whole thing because they had her come back and take over, even though he was supposed to do the autopsy. And she has, you know, speaking of whatever they're talking about here, like you like hypotheses. Well, Dr. G, of course, at the time had that stupid show on, I don't know if it was stupid. I never watched it, but she had her own show on the Discovery Channel. She was a celebrity. Now, I don't know if the jury would have recognized her and knew that or not, but she was considered a celebrity. So
to me, it's high profile.
You were involved.
That's why I opened the head in every case.
Were you involved in the Phil Spector case out in California?
In the Bill Spector case, yes, I was.
You were involved in O.J. Simpson?
Yes, I was.
You were involved in the Menendez brothers case in California?
No.
Didn't get that one?
No.
Deck.
Now, let's talk about the residue in the skull. Where, that exhibit. Now, one other question. What's the exhibit? Oh, I'm sorry, it's exhibit AZ. Is this not an evidence? Oh,
I mean,
It's a blow up of
one that is. Defense 26.
the thing is when you're the most qualified, it would make sense that people want to hire you as an expert, right?
Just as a parenthetical, when you opened the skull, you actually broke it, didn't you?
When I opened the skull, what?
You broke it. Didn't you?
I broke it?
Yes, when you opened the skull, you broke it. Didn't you, Dr. Spitz?
I didn't know that I broke it.
Can you see the crack in the skull right here?
Yes, there is a break there, but I didn't do that. I don't know that I did that.
Oh, okay. This residue that's in the skull that you're relying on for your opinion, did you have that tested, chemically tested?
I did not do any chemical tests. What I did was I scraped some of that and gave it to I kept it for possible testing. Then I was told that this was tested by the county or the I don't know who tested it, but as far as I understood was that it was it found its way to the police, that they tested it,
Okay.
or some police laboratory tested
Who
it.
told you that?
I don't remember who told me that.
Well, my point is, doctor, you don't really know whether that debris, whether that residue is brain dust or just dirt, do you?
No, that's not dark. That is debris, because it is part. That is the settlement of a decomposing brain and surrounding soft tissues by gravity. That's what this is. This is, please believe me, that this skull of Casey Anthony.
You mean Caylee Anthony?
Caylee Anthony is not the first decomposed skull or
but Dr. Spitz,
decomposed remains, skeletal remains that I've opened and found this kind of a residue. This is a routine finding, and it's mentioned in my book that these things occur and should be examined.
Now, but without examining it, you can't truly know whether it's brain dust or just dirt. I mean, isn't that true?
No, this is not just dirt. This is the residue from a decomposing brain, and it goes by gravity to the lowest point. That's what this is.
Now, did you get information about the nature of the area where this skull was found?
I went there.
And you would agree that it's a area that is, were you given information that this area is an area that is at least occasionally underwater based on the seasons?
Yes, I understand that too.
All right. So if this skull were underwater, are you telling us that there's not a possibility that that residue that you identify as brain dust is simply sediment from water?
Yes, it is a sediment. That's correct. It's a sediment of the brain decomposing and falling to the lowest point.
It couldn't be sediment from dirty water that infiltrates the skull as it sits underwater.
You know, this sediment is so common in skeletal remains that have been subjected to extensive decomposition of the brain and soft tissues that it is almost as definitive a finding as to say that here, this is the lower jaw. I don't need to research the background of this to say that this is the mandibular bone in an elderly individual.
This is another example. Like this is great. Remember earlier when I was trying to give an example of something that would be akin to what when he was talking about that you always open up the head, you always examine the head, and that just goes without saying. It's so obvious. And I was like trying to think of an analogy. Well, this that he's doing right here is that exact same thing. But had he not done this, I would not have realized that this question, as just a regular I did not know that. I would not have known that this question about the sediment in the skull was also equally as ubiquitous, that you would see that it's that dumb of a question. Basically, that's what it is. It's that dumb of a question, but he's giving a good example of this, right? Like, and again, it still reminds me of Dr. Russell Undercross from the other day too, where it's like, yeah, that's a jawbone. Like, no one's like, you can't. A question about verifying it is like so unfair because it's like no one would ever do that, right? So
it is almost as definitive a finding as to say that here, this is a lower jaw. I don't need to research the background of this to say that this is the mandibular bone in an elderly individual, a human. So this, I don't need that because this speaks for itself. The same as this speaks for itself, and the same as that speaks for itself.
There you go.
So you don't need to bother to actually have the sediment examined by a chemist or a geologist or a mineralogist or anyone else. You know beyond any doubt that that's brain sediment and not just dirt. That's what you're telling us.
Well, if somebody would analyze it, that would be fine with me. Until such time that they analyze this, that is my opinion. That's correct.
Now, you do realize that the interior of the skull was washed with saline by the medical examiner and a toxicologist to see if they could get any trace elements that might have remained on the skull through decomposition. You're aware of that?
I'm aware that the medical examiner took salty water, so-called saline, put it in through this opening, this hole, where I put my finger or where I put my pen, and then swish it around and removed whatever came back.
So is it your testimony that there's absolutely no possibility that that act of swishing water is why there's no sediment on this side of the skull?
No, the reason that there is no sediment
that makes literally no sense, because then why would there be sediment on the other side, Mr. Ashton?
on the other side is because that sediment
8%.
has a weight to it. As I told you, this is not the first skull that I've examined. In fact, I was able to solve a murder case in California in a
Objection, not response for the question.
Oh, for fuck's sake.
Sustained.
Which objection, Judge?
Mr. Mason's objection.
All right. Go ahead, Doctor, you can finish.
I was requested by the prosecutor of Riverside County, California, to examine a skeleton from Riverside that was buried in the mountains of Riverside and to determine the cause of death. And I opened the skull and
Judge Belvin likes this expert.
there was the same residue as here, sedimented down to the bottom, and I found it loaded with sleeping drug medication and on chemical analysis. That is why the finding here was of such importance. It indicated, when I looked at the skull, I determined that the skull must have been on the left side. Otherwise, that wouldn't be there. So if you tell me that there was brown sediment everywhere, well, this brown sediment obviously did not respond to the swishing of the fluid. This sediment stayed put. Why did it stay put? Because it's sticky. It is sticky in the other cases that I've examined also. And
the thing is Mr. Ashton needs to not ask dumbass questions, because every time he asks a dumbass question, he's going to get an answer like this that just proves A, how dumb of a question it is, and B, how correct this expert is.
And it sticks to the bone. That's why it's there now. And that's why it will be there for probably longer period yet.
But in the other case, you sent the sediment for chemical analysis, didn't you?
I'm sorry?
The California case that you were telling us about?
Yes.
You sent that residue for chemical analysis.
Well, that's because there was somebody to give it to, and that from the prosecutor's office that picked it up. That is one of the advantage of two people doing an autopsy together. Because if that
Objection, Your Honor, not responsive to the question.
Oh my God.
Go ahead,
well, if I had been there with Dr. Garavaglia, I would have insisted that I would have told her, you know what, let's take that and send it to the laboratory. Then we wouldn't have all this kerfuffle about determining what is what when you inject fluid into a closed box, swish it around, and then now we're arguing about where it came from.
Oh my God, this is brilliant. And he's making a good distinction here, which is that the difference is that when he was working at that other case in California, he was hired by the prosecutor, right? And what he's saying is, I wanted to be involved with the autopsy hearing. You guys wouldn't let me. Otherwise, I would have said to Dr. G, let's collect this and send it off. But that was not my choice to make, because that's not what happened.
What it was.
But if you had had the residue analyzed, we also would avoid the kerfuffle.
I'm not a laboratory. I don't have a laboratory like that.
Right.
I can do autopsies, but I'm not a chemist. I don't do tests like that. The laboratory does that.
Could you put your skull back together? I want to ask you a couple questions and use that skull. Okay.
You want me to put that back
Can
together?
you put it back together?
Sure.
And may I approach the witness, Your Honor?
You may.
This witness is awesome. I love him. I love him. Dude.
Do I need to put this back too?
Yeah, please put it back. We're gonna talk about the whole I think we just want to put it in place. I don't know if we need spring action to work with this possible bit later. Now, your theory is that this skull decomposed on its left side or right side?
Left side.
A Hamlet moment.
With the face slightly elevated.
Slightly.
Slightly like.
Oh, here we go.
All right. Now,
No time in
at
the courtroom.
I'll hold it. At the time of decomposition, when the skull gets in this position, the brain is still at least relatively intact, in your opinion, correct?
Yes.
The skin is still on the face.
Yes.
The hair is still on the skull.
Yes.
Correct?
Yes.
As it decomposes, everything decomposes together. Correct?
Yes.
The brain is decomposing.
Yes.
And the skin is decomposing.
Right.
And the hair is sloughing off the skull. Is that correct?
Yes. That's right.
And by force of gravity, the hair would naturally fall this way. Correct?
No, the hair, the hair would move, but whether it would directly fall, I'm not so sure that it falls.
Well,
The hair is, the hair kind of is clumped together in clumps, and much of the tissue receives some of that creamy, soapy stuff that keeps the hair together, and so that even when that eventually disappears, the hair would stay put on the skull.
the hair would stay put on the skull.
Well, it
even
would move. Then people come and
Anthony. That's so interesting. So that's why the hair looks like that. Okay. So like, I'm just thinking about like Halloween decorations, right? Like anytime that you see something that's supposed to, or like zombies or like, you know, in movies where they got somebody that's supposed to be a decomposing or dead person, right? You know, whatever. Like, that's what I'm thinking of. I'm like, you know how the hair, like I've always wondered about that. Like, right. Like I thought it was just supposed to be creepy, but the hair is always all stringy and it's like, you know, and in my mind, I'm like, you know, it's like as if everybody that died had like very little hair, right? Or the hair is all gross and like, you know what I'm talking about? Like just picture any horror movie or any zombie movie or Halloween decorations, right? Where there, you know, the hair is always there, like there's not a lot of hair. It doesn't look like regular hair, right? That makes so much sense what he just explained, which is that what happens is because of the adipocere stuff, right? And the soapy bit he was talking about, that's what makes it all clump together like that and look so greasy and nasty. Now that makes sense.
and move it, and as soon as you touch the thing, the hair gets moved along too.
And doctor, if you can interrupt my question, so I'll get it out, and then the court's not going to have a problem. Now, so you're saying that the skull in this position and the skin has completely decomposed, the brain is completely decomposed, but the hair is still on the skull?
Well, much of it probably would be, yes.
But most of it would have fallen, correct?
Well, only that hair that would be on the left side may so-called fall. The hair that's on the right side must stay put. And you can see that there are structures on the head that would hold the hair, like here, maxillary bone, that would hold it in place. The hair would be entangled in that, some of it.
But the massive hair on the top of the skull would fall.
But not from the right side. It wouldn't go, the hair doesn't go up, the hair goes by gravity, it would go down, not up. And when it comes down from here, it would encounter this structure, and it would encounter that structure.
I understand that. What I'm asking you is about the massive hair on the top of the skull would be expected to fall this way.
Some of it would fall that way, some of it would not.
Well, you would expect if you found the skull in this position that the mass of the hair would be on this side.
No, that's not so. That doesn't happen. So
where would it be then?
Some of it would be.
Well, this expert.
And stuck from the right side, and there would be hair on the head.
It certainly wouldn't fall off the back, though.
The hair from the back, some of it may be spread to the back when the skull is picked up. That hair would probably, being that it is resting on some of the shrubbery there, would stay on the shrubbery because it comes in with that sticky material that's on
it. 219.
The way he just collected his skull back. Hold on. And Mr. Ashton is like not happy. This is like, hold on.
That hair would probably, being that it is resting on some of the shrubbery there, would stay on the shrubbery because it comes in with that sticky material that's on it.
Look at this. Watch.
219.
That's my favorite thing of all time. Oh my God. Oh my God. He's protective over the skull. I love it. I love it. I love it so much.
19.
Your jaw.
Doctor, do you recognize, can you turn your screen so you can see it? Right here. I'll show you a photograph. Do you recognize this as a photograph, one of the medical examiner's photographs of the appearance of Caylee Anthony's skull and remains at the medical examiner's office?
Yes.
And may I this is in evidence. May I publish, Your Honor?
May.
Now, you would agree, always forget about the delay. Thank you, sir. You would agree that the mass of this hair, the vast majority of the hair, has fallen back, not to the side. Wouldn't you agree?
Sir, you're looking at this picture. Shows the skull like this.
Correct.
Oh dear.
Like this.
Yes, sir. And the hair mass has fallen to the back of the skull, not to the side. Isn't that shown in this photograph, Dr.
The hair is the hair that she has long hair, and the hair is sitting on the base of the skull. If you look at this, the back of the base of the skull has, and the sides here, has hair. And the hair is sort of glued or sticky to the bone. That is that hair which matted itself to the skull when the skull was placed, or when the head was placed in that location.
But you would agree that this photograph indicates, excuse me, sir, Mr. Spitz, if you need, let me finish the question. You would agree that this photograph shows that the hair mass has fallen backwards, not to the side. Wouldn't you agree, sir?
The hair on this picture, location-wise, speaks for itself, where it is. And much of that hair is on the base of this skull. Like here, let me show you. If this is the matted hair.
Good, I'm glad.
If this is
oh my God, brilliant. I'm so glad he's doing this because, of course, we aren't, the picture speaks for itself, but we don't get to see the picture. Like this whole time I kept thinking, you know, as awful as I'm sure the picture is, it sucks because this is such a thing of this is such a big point of dispute that has been going on for this whole trial of the location of the hair and whatnot, right? And it's like, we don't actually have any idea. This is the first time we're going to get an idea because he's going to use his Kleenex to show it.
Matted hair.
I love this. Brilliant. Brilliant.
This is the matted hair.
Oh my God.
Skull is like this, and the hair would be here, here, and here. That's what you see.
So your
what you see.
Your recollection.
Let me show the
oh my God.
That's what you would see.
So
that is what this picture shows.
Doctor, so is it your statement that the photographs show that there is hair, a considerable amount of hair on top of the skull, that it hasn't all fallen, almost all fallen to this back and the sides?
I don't see any evidence on this picture of what you call fallen hair.
Wow.
This hair is matted and is, you tell me that there's water, maybe the water washed it to the water washed around it and splashed the hair onto the bone and wetted the liquefied scalp to the bone and attached it to the bone, glued it to the bone.
So the water.
So he's saying it's
displaced.
the opposite. Mr. Ashton wants to say the hair has fallen. He's saying it can't. It's the opposite. It's stuck to the skull.
The hair,
maybe,
but it didn't displace the residue.
I don't know if that's what happened, but that could have happened. And it seems quite likely because that happened because there is no hair on the base of the skull. So now there is hair on the base of the skull on the outside, on this surface, on the outside. How did that hair get there? There's no other way for the hair to get there.
The hair can't just slough off the skull when the skin, which held it to the skull, has decomposed and no longer exists.
The hair, in order to not exist, it underwent a process like adipocery, or melting down, breaking down, and that yields materials which are sticky.
Did you look at this hair?
On the pictures.
Do you know whether it's sticky in its present condition?
Well, I know that it's sticky because I've examined other hair, not this hair. But I mean, that is a fact that this.
And to that end, you know, I'm sure it'll come up, right? He wanted to be there to examine it, and they wouldn't. They wouldn't allow him to be present.
Hair was not located in a clean, what we call clean environment. This hair was subjected to decomposition, and when decomposition finishes, the dried up adipocery is still there and helps stick the hair to the bone.
You would agree, however, that this photograph does not support the position that you have theorized the head decomposed in, because the hair has not slid to the side.
No, I don't see why that contradicts it. This is to be expected. If you said about this area is submerged at times, and that would be totally consistent with it.
Now, let us proceed now to your other theory about the duct tape. Is it your opinion that the duct tape was applied to the skull after it was fully skeletonized?
It is my opinion that the duct tape was stuck on there after the skin had deteriorated, after the skin was decomposed.
How did
through the whole process of adiposity, you see the skeletonization here. You see it. It's looking at you. It's looking at me. It's almost in this condition, except it's not been handled, at least not much. At the scene, there's debris. There is because that area is full of debris.
No, may I object to the narrative? It's not responsive to the question I asked.
Doctor, had you finished answering the question, sir?
I have.
Okay, thank you, sir.
Now, how did this person do that? Describe for the jury how, in your opinion, this person actually did that. Put duct tape on the skull.
I'm sorry, I don't. How the person
What?
Did what?
How this person that you have hypothesized put duct tape on the skull, how they did it.
Well, they took a piece of duct tape in a roll. It comes in a roll. I'm sorry, I didn't bring you a roll to show you. I have a big roll in my office, and tore off a number of sections, maybe this long, and stuck them on the skull to possibly to do what I did, so that I can show it with springs attached the lower jaw, the lower jaw to the rest of the face.
Well, let me start with the first level. Is it your theory that your theory is that the skull and the body decomposed at the location where it was found, but on its side? Do I have that correct?
On its left side, yes.
Right. Did the person, in your opinion, come over and pick up the skull from the ground? Is that your theory?
You mean, I don't know if the duct tape was applied when the skull was on the ground, or whether the duct tape was elevated when that was done. That I cannot tell you.
Well, how could
I mean, I'm a fairly good forensic pathologist, but I cannot tell you an answer to that question, whether it was elevated or whether it was on the ground.
Well, if the skull is on its side, someone would have to pick it up in order to place duct tape over the front going to the sides.
Maybe. I don't know. Maybe yes, maybe no.
Well, and when they picked up the skull, the mandible would have stayed where it was. Correct?
The mandible would have what?
In other words, when they pick up, if the body is completely skeletonized, then the mandible and the skull are not connected, correct?
Well, they are connected until the skull is moved around, and then they're not connected. It's not connected because the soft tissues that hold the skull to the lower jaw, those are gone. So it's like I said earlier, when I picked up this skull, the mandible, the lower jaw, which is the mandible, fell down here on my back.
Exactly my point. This person had to pick up the skull and then pick up the mandible, because they would be separated, correct?
Unless you use duct tape and stick it back on.
But he hasn't duct taped it yet. We're getting there.
Well, okay.
He picks up the skull, he picks up the mandible.
Yeah.
This person then would need to place the mandible back in anatomical position in the skull. Isn't that correct?
Possibly. I don't know how well it was attached.
According,
I don't know. In the pictures that I see here, there is no mandible on this picture anyway.
Correct. But do you recall from the report of the autopsy and the forensic anthropologist that when it was found, the mandible was in virtually its anatomical position?
Right.
So this person would have had to take the jaw, put it back in anatomical position. Correct?
Yes.
He then would have had to have taken a piece of duct tape and placed it around the bone itself.
On one side.
Well, do you recall from your readings that the duct tape is on both sides?
The pictures don't show it like that. I don't have a picture. Maybe you have a picture. I don't remember a picture that shows it on both sides.
Oh my God, it's not. And that's one of the whole things that's been talked about this whole trial.
We'll just take, for purpose of my hypothetical, that it's on both sides, and Terry will see has seen the photographs already. So he would have had to take, here's another point. If you're trying to attach the mandible to the skull, you would have to do it on both sides, correct? If your theory is correct.
Well, that depends on how long the duct tape is. I don't know whether it was on both sides. I remember it on one side, and the other side, there was no duct tape that I could see. But if you tell me that there was duct tape on both sides, so okay, so there was on both sides.
But if your purpose, as you've hypothesized, is to connect the jaw to the skull for some reason, you'd have to do it on both sides.
If you want a better bond, yes.
This person actually, though, would have done it with 3 different pieces of tape. Were you aware of that?
I know that there are 3 pieces of duct tape.
So why would it take 3 pieces of duct tape to stick the mandible to the skull if, in fact, that was what you wanted to do?
Well, because there was what I gleaned from the pictures again, there were two pieces of duct tape superimposed one on top of the other, and the pieces were not terribly long to reach the other side. So maybe one side was done, and then there was another piece of duct tape put on top of that, so that would extend the total length of the duct tape to afford it to be on both sides.
For purposes of our discussion, you may accept that the pieces were 6 to 8 inches long each, and there were 3. For purposes of our discussion. Pardon?
It was what?
Each piece was 6 to 8 inches long, and there were 3 pieces.
There were 3 pieces. One piece was like 9 feet away, I understand.
Yeah, the 4th piece was 9 feet away.
Yep.
Right. Okay, so this person would have taken this skull for whatever reason and cut 3 pieces of duct tape and wrapped it around the skull, actually putting the adhesive on the skull itself. This is your theory, correct?
Yes.
Why is there no glue residue on the skull?
There's no glue residue on the skull. There was no residue of duct tape on my skin that I put on directly on when I put duct tape on my forearm. There was hair on it, but there was no glue.
But this is bone, not skin. So why is it?
Why would bone be any different? In fact, bone is much more solid and dense than skin. So why wouldn't if there isn't any on skin? Why would there not be any? Why would there be the residue on bone?
You do realize that the duct tape was not actually stuck to the bone when it was found. You do realize that.
I realize that, yes.
Why? Why isn't the duct tape, under your theory, still stuck to the bone?
It's not stuck to the bone.
But why isn't it?
Pictures don't show it stuck to the bone.
But why isn't it?
Well, because there's intervention of water. The water will usually remove some of the glue, the stickiness of the glue. So why not?
So if this person removed the skull, attached the mandible to it, and put 3 pieces of duct tape on it, and then set it back where it was, is that your theory?
Or take it with him and then bring it back and put it back to where it was. Or to take it to where he or she wants to put the duct tape and then bring it back and put it back in the place.
Then why is the hair the only thing that's stuck to the tape?
Well, the hair would stick to the tape.
But you said that the tape was put on after the skull was removed. So how can the hair be stuck to the tape?
I don't know how the term stuck to the tape is applicable here, because I'm not so sure that the tape was really still in a condition that it enables stickiness, that it preserved the tape preserved the stickiness through this entire ordeal. Heat, water, that takes away some of the stickiness.
For purposes of our discussion,
yeah,
would you accept, or do you recall from the autopsy report that Dr. Utz, the doctor that removed the tape, had to cut the hair in order to remove the tape because the hair was stuck to the tape? Does that sound familiar?
Well, some of this, yes, I did.
I'm going to go ahead and say, too, right, that wouldn't it be that if the hair and tape were stuck together, it wouldn't necessarily be because of adhesive from the tape. It could be because the hair is sticky, because the soapy, sticky, the adipocere stuff, right?
Some of this hair is probably there, and some hair would probably not be there. So some of the hair she may have needed to cut, and some of the hair she did not need to cut.
Could I have State's Exhibit 215 and published to the jury, Your Honor?
Right.
You see this photograph, Doctor?
Yes.
And then this person who picked up the skull, attached the mandible, attached 3 pieces of duct tape, put it back, then had to drape strands of the hair over the skull. Is that your theory?
Would you say that again? Because
Sure.
I don't understand what your question has to do with this picture.
Do you see these strands of hair that are on top of the skull?
Yeah, they're just lying there.
Your theory is
These pieces of hair, excuse me, these pieces of hair were put there. They did not stay like that.
They were put there.
Yes, the person who took this picture, or the person who prepared this picture for the photograph to be taken, put the hair there.
So your testimony is that the medical examiner's personnel took the hair that was not on the skull and placed it there for the purposes of this photograph?
Wouldn't be the first time, sir. Wouldn't be. I can tell you some horror stories about that, where people sat in jail for a long time because of somebody removing bloody clothes and putting them in the trash can, and those were police officers.
May I publish State's Exhibit 209
Oh,
to
wow.
the jury?
Right.
Do you see this photograph, Dr. Spitz? Do you recognize this as a photograph of the skull as it was found at the scene?
Yes.
And do you see the strands of hair draped over the skull?
Yeah, but this does not look like, yes, I do, but I do not see that this picture is identical with the picture that you just showed me.
Is it your testimony that the medical examiners who took this photograph at the scene took the hair and draped it over the skull for purposes of this picture?
It is my opinion that somebody did. I don't know if it's medical examiner or not medical examiner. I cannot tell you that because I don't see fingerprints on this. But if you compare this picture with the other picture that you just showed me, they look different. And why do they look different? Because somebody rearranged it.
Wow. Wow.
Redirect.
Interesting. I wish we.
Dr. Spitz, you were asked.
Because, like, you know, it sucks because, like, I mean, I believe him more than Mr. Ashton, right? If he says they look different, but like, it sucks because without seeing it, it's hard to know because, you know, sometimes you have experts who are just not willing to admit they are wrong. And so, you know, and stuff like that, where it's like, you have to see the thing to see what it is. But we'll see what happens here on reading.
Asked a little while ago, Mr. Ashton, if there were any other reasons for opening the skull than the general autopsy protocol. Do you remember that question?
Yes.
Are there other reasons why you would open the skull?
Sure.
And what are they, sir?
Well, first of all, just for to mention, if you look at medical legal investigation of death, I don't remember the page number, obviously, but there are occasionally fractures that will not fracture the outside of the skull. So what does that mean? That means that here's the skull put back together. If there is, let us just for the sake of argument, if this kind of a force is applied to the skull, of the skull, for instance, you can find, when you open the skull, you can find a fracture on the inside, but nothing on the outside. That's one. The other thing is that in a case of, in certain types of death, there would be hemorrhage to the, in certain locations on the base, in the base of the skull. I think I mentioned that earlier. In the area of the middle ears, in the areas of the, this bone here behind the lower jaw, which would contain a coloring that's in the bone that is difficult to remove from blood that had accumulated there, which is not here, did not occur in this case. Another thing.
Doc, what other types of death would cause that hemorrhaging and discoloration by blood on the base?
Well, it doesn't occur each time, but in a good number of times, there's hemorrhage in those locations in cases of asphyxiation by smothering or by strangulation.
And how does that occur?
Well, because if you smother somebody, the blood pressure goes up in the head area, and then blood vessels break, and that's the location where you get the evidence.
So in many occasions, if there is a suffocation, an asphyxiation, the blood pressure alone will cause there to be hemorrhaging and discoloration on the base of the skull.
Well, as I said, it doesn't happen every time, but when it happens, when the blood decomposes, it leaves a residue, and the residue is colored.
You were also asked by Mr. Ashton, sir, if you had sent the brain matter, he refers to it as dust, the sediment, for chemical analysis, and you respond, you did not.
No, I did personally not. I don't have the facility for that.
You read all of the reports from the autopsy by Dr. Garavaglia, did you?
Yes, I did.
Okay. Did you learn that, in fact, the matters from the autopsy were sent to Dr. Bruce Goldberger, a toxicologist in Gainesville?
Objection. Specification of what matters.
Pardon?
Relevance, not specification of what matters.
Overruled.
Yes, I did.
And did you read the results of the toxicology screens by Dr. Goldberger, sir?
Yes, I did.
Did Dr. Goldberger find the presence of any form of poison?
No, he did not.
Did he find the presence of any amount whatsoever of chloroform?
Scope across.
Overruled.
I'm sorry, I didn't hear the question.
Did he find the presence of any amount of chloroform?
No, he did not.
Wow.
Now, the last issue Mr. Ashton was asking you about is the presence or location of duct tape, right?
Yes.
Do you know how many people had handled that skull before it was photographed in the medical examiner's office, sir?
No, I do not.
Do you have an opinion by looking at those photographs whether, in fact, of necessity, that skull was manipulated to take the photographs?
Well, it had to be manipulated. I mean, there's just no way that it was not, because manipulated means, manus in Latin means hand. So manipulated means that hands were laid on the skull.
Yeah, right.
Why do I know that? Because it's positioned on a brown paper for the purpose of taking a picture. Well, the skull didn't walk there. The skull didn't go there. The skull was put there by hands of somebody. And in the process, the hair had to be rearranged. That's why the hair in the office, in the presence of the camera, looks somewhat different than the skull with the hair, with the position, placement of the hair.
I'm glad Mr. Mason asked this question because it's explaining that the hair being slightly different wasn't done in any malicious way or, like, because he gave an example on cross about, law enforcement with another case and they can do this and that. And it's like saying, well, no, it wasn't like somebody intentionally did it, but just because it had to be picked up. Right. And that makes sense. That's fair.
On the skull at the scene. There's just no other way.
So somebody had to do it.
Somebody had to do it, sure.
No further questions, Your Honor. Thank you.
No questions from the state.
May the witness be excused.
Thank you.
Thank you very much, Doctor.
Sorry, I was just
Okay, ladies and gentlemen of the jury, this concludes the presentation for evidence today. We will see you Monday morning at 9 a.m. Please remember all of my other previous admonitions. Thank you.
okay. So
Okay, folks. So there will be no confusion about which order I was talking about. It was an order that was entered on January 6, 2011. Order granting state's motion for sanctions / motion to compel.
okay, so this is going back to earlier when they were. Remember, he asked them to produce the order, and then they found it, and then he didn't ask them again. So now we're finally getting the answer. What did the order say specifically? And remember, they're ending the state early, and it must be a Saturday, so that they can take the deposition of that other expert. So yeah.
Which specifies the requirements of reports, what are to be included in those reports. So let's make sure you reread that in comply so we won't have any more hiccups.
He's not telling us what it says, though. Dang it.
Be prepared next Saturday to work, if necessary, up to 3 p.m. So I will probably let you know, but going through one witness a day is not going to get us
right
where we need to be. But at the same time, I'm not going to hurry you. We will just extend the working hours. So just be prepared to work longer on Saturdays. And if necessary, we may extend the work hours.
Because what they have been doing for Saturdays is they've been going till 1 o'clock on Saturdays. He's saying they might need to go till 3.
Well, to 5:30, 6 o'clock. But I'll make that evaluation at the close of business on Tuesday. Okay. Any other matters we need to take up from the defense? Okay. We'll be in recess to 9 a.m. Monday morning.
All right. So they're going to have that deposition of that expert, and then they have Sunday off, and then they return Monday morning. And guess what? Due to the magic of watching this after the fact, it is already Monday morning at 9 a.m. for us because we are carrying on. So here we go.
Okay. Who will be the defense's first witness for today? And Mr. Ashton, you indicated that there may be an issue with Dr. Rodriguez.
Yes. The first.
Okay. So remember, now at this point, they've taken the deposition of that Dr. Rodriguez, and now we're going to hear what Mr. Ashton has to say about that.
Issue is the court had left the issue of a sanctions package as to this witness for later consideration. We did take his deposition from 1:45 to approximately 3:45 on Saturday. I just received a transcript of the deposition.
Glad you're here. Happy to see you.
Yesterday, I read through it once. I would like to read through it again in preparation for cross-examination. So number one, I would ask that this witness not be called immediately because obviously I need time to consider what he said. There's one particular area that he proposes to give an opinion that the court would need to review the transcript that I don't believe he is qualified to give. Specifically, just to summarize it quickly, he proposes to give an opinion that other people can't distinguish human decomposition from other odors.
Oh,
and to very briefly state it, he, after some considerable
doesn't surprise me at all, right? My God.
questioning, he finally came down to say essentially that it was just based on his personal experience rather than any studies or scientific literature.
Oh, but that's not fair because literally that's what everybody else said. Everybody for the state that said they could tell what the odor was, it literally was based on personal experience. And even Dr. Vass even said, chemically, there's nothing that distinguishes it from any other thing, and that there's no studies or whatever that can actually look at the smell and say this is from a human. So,
but anyway. I would like for this witness not to be called first because obviously I need to have time to prepare for cross-examination from this lengthy deposition that we took and have a hearing on that one issue, which because of the violation of the discovery order, obviously I was not able to do. The one opinion I just mentioned is an opinion that was not contained in his original report. So it is new. There are other new opinions as well that I may be able to deal with on the fly, but I would just request that counsel not be permitted to call this witness until I've had at least half a day or at least some kind of break to digest the deposition and prepare for cross-examination because of the discovery violation.
That's
the other issue that I mentioned at counsel table is at sidebar is as to a witness, Mr. Eichenblum. Just so the court has this, and I don't necessarily want to argue sanctions on this right now, but I just want the court to know it's coming.
Oh boy.
We received a a half a page report from Dr. Eichenblum pursuant to the court's order that essentially contained no opinions or conclusions of any kind. Mr. Eichenblum showed up Friday outside and prompting us to question counsel about what he was here for, since his report indicated nothing, essentially. Yesterday, and Mr. Eichenblum showed up at my office yesterday afternoon for a potential deposition, but I sent him away because without a report, I have no way of deposing him. I received a report, which is 2 pages in length, and a 45-slide PowerPoint presentation yesterday from counsel. I'm providing the court with both. I am willing to depose Mr. Eichenblum Tuesday evening and to do as much as I can. I will be preparing a sanctions package for the court because, again, this is, I believe, another deliberate violation of the court's order. May I approach?
You may. What is Dr. Eichenblum's field of expertise?
I think he has phrased it as DNA and trace evidence or crime scene evidence, something general in that sense. It's in the report. He is proposing to give a number of opinions on, I guess I should say, the interpretation of negative DNA evidence. But it's reflected in his report. Again, I'm not prepared to argue the issue now because obviously I haven't deposed him yet. I need to do that, and I will do that on Tuesday at 5:30, should the defense produce him. So those are my requests at this point, is that Dr. Rodriguez not be permitted to testify until I've had time to review and prepare for cross-examination because of the last-minute nature, and that Mr. Eichenblum be ordered to appear. I will be presenting the court with additional requests for sanctions to alleviate the prejudice. But at this point, those are my initial requests.
Under Rule 3.220, the prosecutor is afforded the right to take deposition.
I wonder what's going to happen, because is Judge Belvin going to view this as a second happening of the issue that we had with the other witness? Remember the whole thing about lightning doesn't strike twice? Like, is he going to consider this to be the same thing, or is he going to consider this to be different? I'm worried for Mr. Baez. Also, look at his awesome outfit, though.
Positions in a case. This is a capital case for which he is prosecuting and seeking the ultimate penalty. The witnesses in question were listed timely and were ordered by this court to issue a report
under
time constraints.
Right.
I immediately instructed each witness to put together something as quickly as possible.
And I wondered if that's why the report was late to get to the prosecution, because of that.
Despite having the proper amount of time to ensure that every single opinion that they have that may come up during the course of trial, which is clearly an unscripted event, would allow them to put something together to completely comply with the court's order. The court's order under Section 4, Section 4, Paragraph 4 states, opinions not expressed in a written report or, emphasis added, at deposition taken during discovery will not be permitted at trial. The prosecutor in this case has attempted to narrow the scope of the testimony of these expert witnesses by intentionally refusing to take their depositions.
That's what we
I say this is an intentional act because it is clear that there was a sufficient time period for Mr. Ashton to coordinate these witnesses for depositions, set them, and conduct them. This package that he claims to put together or want to put together can easily be done for him, as the state has violated this order itself.
I was literally just going to say, wait a second, shouldn't he be asking for the sanctions on the state?
On two occasions, one with Dr. Rickenbach.
Right, exactly. Yes.
Which was taken at sidebar.
Yep.
The objection was sustained because he wanted to elicit testimony outside of his reports or deposition. And it was quickly moved on with no threats of any sanctions and no threats of being held.
I also referenced that earlier. What I referenced earlier was how when this happened before, it was just, they just can't testify to that new opinion or whatever, but there was not, that was it, right?
Contempt of court.
Yeah.
Furthermore, when the FBI, with the late disclosure of photographs, the morning of trial.
Right. I know. The photographs just didn't come in.
That too was addressed and moved on. I think that the court has made it clear that this is not a game and that gamesmanship
has been exercised by both sides. And I think that this is nothing but a clear exercise of gamesmanship that is carried on from Mr. Ashton from the very beginning. He is a skilled and experienced prosecutor that knows that with expert witnesses, you should take their deposition. I would venture a guess to say that he has never had a trial where he has just completely ignored expert depositions, especially those such as important as these. But yet he was armed with a court order, which he thought he could play.
Exactly, because Mr. Ashton is like, well, if I just don't take their deposition, then I can say this is a new opinion or whatever. Yeah, I
games with and use as a sword and both as a shield by completely and intentionally ignoring his responsibilities as a prosecutor to go forward and fail to not take a deposition.
So in other words, this is the second instance of this happening, and it's going to be again. To me, it does look like it's the state's fault. They didn't take the deposition, and they could have, and they should have, right? Or is Judge Belvin going to blame the defense and say you should have turned over the stuff sooner?
Pertains to Dr. Rodriguez, the remedy under the law is to give the prosecutor time to take his deposition. These things occur on many occasions, and these are really minor issues.
Y'all, is he going to have another schizophrenic moment?
The duct tape opinion.
He's doing it again. Hold on. Another schizophrenic moment.
His deposition. These things occur on many occasions, and these are really minor issues. The duct tape opinion that Dr.
I asked if you remind me where you're at. I mean, if you, I feel like you have. I'm just wondering because I know we've got some California squirrels. I just want to make sure everybody is safe. And I can't quite recall where you're joining us from, but Mr. Ashton is clearly having another schizophrenic moment.
Dr. Rodriguez is simply going to express is that there's no scientific basis to render an opinion as to where a piece of duct tape is when it is on a surface deposit site, because there are too many things that can alter the location of this duct tape. This is, aside from being common sense, this is being testified by someone who has the experience to do so. As it pertains to Mr. Eichenboom, we have attempted to.
Oh, you are in California. Okay, so that's what I thought. There was a reason I thought. Okay, you must have said that. So, where are you in reference to the fires? We had Candace here earlier letting us know how she's doing. She said that the fires were headed towards UCLA. You're enjoying the Southern accents. Awesome. Yeah, Mr. Mason, if you haven't heard him already, has a really special, really kind of like old-fashioned Southern drawl that's really delightful, and you don't hear as often too. So, but yeah, let us know where you're at and if you're safe. Yeah, it's terrible. And I hope that they're getting it under control.
Failure of taking his deposition and what he might be able to testify to. One of the issues that we originally wished for him to testify about is the aspects of DNA. Low copy number DNA, degradation of DNA, all of which was given notice to the state, not only through my response in the pleadings to the court, but this is a common issue that the state is on notice of. Their claims that, and their potential arguments that the reason there's no DNA on these items is because of the elements. Knowing full well that could degrade certain DNA, but there still should be DNA on these items. And one can obviously and potentially testify to that. Some of the issues that came up with this case have come up recently, and I because not too many arguments were laid forth as it relates to Mr. Eichenboom, I'll keep my comments to a minimum. Mr. Eichenboom, as I expressed in open court Saturday, that we will be taking that we will be wishing to exercise all of our depositions for any potential experts where the state has failed to do so. I asked and instructed Mr. Eichenboom to show up to the state attorney's office on Saturday afternoon, of which he did, and he was turned away.
Wow.
Specifically by Mr. Ashton, not by an associate, not by a secretary. Wow. Mr. Ashton told him to go away. Upon doing that, I instructed Mr. Eichenboom to prepare a report and to ensure and to do it immediately, of which he did. It was sent to me, and I forwarded it on to Mr. Ashton on Saturday evening, as well as any potential demonstrative aids for which he may find useful in explaining his testimony. That was also disclosed and turned over to him immediately. All of this is stuff, and all of this is information that just merely explains DNA and its processes, and that most of which I'm certain that Mr. Ashton, with his experience, would certainly be aware of and would need very little preparation in light of. Now, I think, as to Mr. Ashton's argument about wanting extra time to now review depositions, well, that's not a very good argument, considering the fact that for several months, approximately 7 or 8 months, he sat and decided not to take a deposition and not to prepare for this trial as needed. Mm-hmm. So because of his intentional omission, he now wants to delay this process. He wants to delay our time, the court's time, the jury's time, for something for which is his professional responsibility to carry out. The order, while the order is fairly clear, and I read this order to include 2 aspects of the discovery process. One, which is written reports, and the other which is deposition. The goal of this court was to prevent any gotchas. I specifically noticed that Mr. Ashton was intentionally omitting, or may omit, I should say, to prevent himself from taking these depositions. And I brought it up at a status hearing. And I warned the court that this may be an issue later on because the state is attempting to use this both as a sword and a shield. We did not intentionally look at this order and say, we're going to disobey it. Just the mere thought of that disturbs me greatly. And it disturbs me that anyone would either A, make the accusation, or B, even assume it to be true.
Well, the other thing I was thinking too is I was like, why would anyone deliberately not follow the order? Like, there's no reason to do that, because it's like, you're just going to have to turn the stuff over anyway, and you're going to get punished for it. So like when Mr. Ashton said that, I was like, why would they even do that? It doesn't make any sense.
And I say that because I have labored on this cause daily, nightly, and it was made clear by the court to me that this court intended on issuing orders and enforcing them if need be. I see that even though the rules of discovery and the law does not compel us to ask experts to issue reports, this court ordered that. However, I think it is a severe and due process violation to try and limit our testimony, limit our presentation of case, because a prosecutor decides on his own, without assistance or acknowledgement from the court, to omit his professional responsibility and to omit his duty to carry out and utilize those tools which are afforded to him under the rules of discovery, and then attempt to use that as some form of sanction. Okay. It's not bad enough that he wants to omit these responsibilities in the efforts of taking a human life. He wants to go after her lawyer too. And I think it is repulsive, and I think it is also not under the law, and shouldn't be dignified in any way, shape, or form by this court. He had a responsibility. He intentionally omitted that and neglected it, and he should not be allowed to come forth, not even at the 11th hour, at the strike of 12, and decide, okay, now I want to utilize something, and do it in a manner that is, I don't want to use the word disingenuous, but to do it in a manner where it's unreasonable. It's unreasonable that he should think that Dr. Rodriguez would have opinions such as these. These are obvious opinions. These are obvious things that, these are obvious troubles with their case, and they know it.
Oh boy. Okay. What is Judge Belvin going to say? Somebody's going to get yelled at big time.
I'm going to ask both sides to turn around and look at that clock back there and tell me what time it is.
Oh my God. Uh-oh.
Mr. Ashton
9:25.
and Mr. Baez.
9:26 is usually the number.
Okay. All right.
I saw where that was going.
That shows that the two of you will never agree on anything and will never interpret anything the same way. That jury has been sitting back there for more than 25 minutes.
Oh dear.
Sergeant, what time did the jury arrive here this morning?
Been there for an hour, sir.
Okay. Henceforth and forevermore, all the attorneys are required to be here exactly at 8:30. So if you have any matters you need to take up, you will notify the court deputy. The court deputy will call me and we will take those up at that time. At 9 o'clock, we will start. No more will we have this. This coming Saturday, we will work a full
Oh my
day.
God.
So be prepared to have witnesses here to work a full day this coming Saturday. The rules of criminal procedure lays
Somebody's
out
gonna get
what
their ass
is
handed to 'em.
discoverable, but it does not take away from the power of the court to order additional discovery, restrict discovery, or set whatever timelines this court feels is necessary. I will call your attention to an order entitled Order Granting State's Motion for Clarification or to Compel Compliance with Order for Additional Discovery, which is dated December 10th, 2010. I'm not going to go into the history of why this particular order was issued, but this is the pertinent portions of that particular order. Where the experts have not prepared reports of examination of tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in forms of written pleadings. The expert's curriculum vitae or qualifications of the expert, the expert's field of expertise, a medical certainty, a statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinion and grounds for each opinions. That was done because there were a couple of reports that basically contain nothing. The court thought that order cleared up the situation.
Oh dear.
Here we go again.
Oh dear. Oh dear.
On January
I still
6th.
have no idea who's going to get their ass handed to him, but it could be both. It could be both. It could be both.
2011. The court entered another order. Order granting state's motion for sanctions and motion to compel. Again, there was some lack of understanding of what the court may have meant. A statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinions and the grounds for each opinions. The court gave out an example of what was submitted on behalf of Dr. Henry Lee.
Oh boy.
Court goes on in its order and says that the defense shall provide written reports to the state from all expert witnesses, which
I don't know that I knew that Henry Lee was involved with this case. No, I knew, but I forgot. He's not testified yet. I don't know that he will testify. I have no idea, and I'm not going to look into it because this is going to be a crazy surprise. So I think I knew that he was involved with this case, but it was long before I decided to cover, and I didn't even connect the dots with that because I hadn't seen him like on the witnesses when I've been going through. So, but having said that, that doesn't mean he's not there, and I just didn't see it. So interesting.
Shall include the following information: a complete statement of opinions the witness will express, and the reason for those opinions, and any data or any information considered by the witness informing their opinions or conclusions. The court in those two orders required both the state and the defense to have expert witnesses list all opinions that they would give. The purpose of depositions are to expound upon those opinions. And as all lawyers know, there is an opportunity for sub-opinions once someone gives a main opinion that they may want to discuss. It has never been the intent by depositions to alleviate the responsibility, and that was not the intent of this court's order.
Okay.
To rely, say, well, you could either take their depositions or the report. The orders are quite clear to me.
So then
this court does not make threats.
So then he's going to get mad at the defense, I think.
This court simply applies the rules. When the state of Florida had an exhibit that they wanted to introduce, i.e. a demonstrative exhibit that was not given to the defense, that exhibit was excluded and the state was not allowed to utilize that exhibit. The court on Saturday indicated that it was put in a proverbial corner, not being able to exclude these opinions by the defense. If you read all of the cases dealing with exclusion of evidence, particularly Dumas, Wright, Lott, Odom, and U.S. versus Hobbs, it frowns upon that because you punish the defendant. But
right. Okay. So that answers my question. So that's based on case law it's based on Florida Supreme Court case law. Okay. So I was mentioning earlier when this was coming up, right, about how with the state, right, what was the solution? I was like saying how I don't know why this is a big deal, because like with the state, that just doesn't come in, right? It's like they just, if it's a different opinion, they just don't do that opinion, right? And I was wondering why it seemed different with the defense. And I was thinking maybe it was because of what did I decide? I had, what was it? I guess I thought maybe it was because of the timing of learning about a new opinion or something. I can't remember what I decided it was, but anyway, but I was wondering why the solution wasn't the same, right? When this problem came up now, but now we're learning that's because there's Florida Supreme Court case law that says that it's a big deal. I'm assuming is what he's going to say. A big deal to exclude expert testimony from the defense. So in other words, if there's an expert for the state and they have a new opinion or they go beyond whatever, you just exclude that testimony. Same thing with the pictures that weren't turned over in a timely fashion. So that's why they're going through all this, is because when this happens from the defense's side, it's considered prejudicial to exclude it. So you want to, in other words, the idea would be find some other measures so that you cannot exclude that testimony. So that makes more sense because, yeah, okay.
The Florida Supreme Court.
In other words, you deal with it differently when you have these different issues coming up with experts. In Florida, it's dealt with differently depending on if it's the state or the.
What did not close the door on if someone continues to repeatedly violate orders of the court, it leaves the door open, regardless of those severe due process considerations, that as the final ultimate sanction. There's never been a case where that final ultimate sanction has been imposed and upheld by a court that I know of. But one would surmise that if someone continuously violates a court order with impunity, whether or not the court would be left powerless or whether or not the Supreme Court will say, this is the case, despite the due process implications, where the ultimate sanction of exclusion would be proper.
So what he's saying, so the ultimate sanction, right, for this, what he sees as, these violations, the ultimate sanction would be not allowing that opinion, that specific opinion in, right? And what he was saying is that there's never been a case in Florida yet at this point, right, that has made that decision because it's considered to be that big of a deal and that prejudicial. But he's saying potentially if there's ever a case that could deserve it, maybe it's this one, but we'll see what else.
Yes, there have been gamesmanship in this particular case, and it is quite evident that there is a friction between attorneys. That is something that I guess the Florida bar will deal with.
Oh boy.
And at the conclusion of this trial, this court will deal with violations which may or may not have occurred, but it is not proper for the court to deal with it now.
I agree.
During the pendency of this very serious litigation. As to the request of the state to defer the testimony of Dr. Rodriguez, I will grant that request. Now, I've announced to both the state and the defense that we're going to have a short day on Wednesday. And that's because of me. And I've explained to the lawyers the reason behind it. Let me say this to both sides. If I was the state or the defense.
So from what I can understand, he defer. So because there were a couple different experts that they talked about, but he only made a ruling on one. So that's the dude that tried to testify previously, as in day 20 or day 21 of the trial. The guy who we saw at the beginning of this episode, right? William Rodriguez III. So that dude, in other words, the ultimate sanction is not being imposed yet. He's not being excluded. His opinions aren't being excluded. He's deferring it, which is one of the things that the state asked for, which is to give him time, Mr. Ashton, time to go through the deposition and whatnot. So in other words, he's just going to have to delay or testify later, it looks like.
I would make sure when we recess this afternoon that I would go through the reports of all my experts and make sure that their opinions were contained in the reports or depositions. As I explained to both sides, sub-opinions, as long as it's under that general area on minor things, those are going to come up either in recross or direct. You can't anticipate everything, but enough is enough. And both sides need to be forewarned that exclusion, even at the price of having to do it all over again, which I don't think I will have to do it all over again because of repeated violations. Exclusion may be the proper remedy if it continues. So,
okay.
Who will be the defense's first witness?
So my guess is that they were planning or thinking that they were going to have Mr. Rodriguez, right, testify, but he's going to have to be deferred. So,
Judge, our second witness that we had intended on calling was Richard Eichenboom.
Oh.
But if in light of that, we have to wait. We're in the process of picking up the third witness. It would take approximately 30 minutes to have her here.
Okay. Inform the jury that, and take them out since they've been locked up in that room for quite some time, that we will proceed at 10:25. Okay? To starting this proceeding every morning at 8:30. And I know that would bring some problems, but at the same time, I've been trying to be accommodating with the work schedule for everyone. But I have a sequestered jury who live under severe restrictions. And if y'all don't want to act professional, then I will work you real full days. Act professional.
Sorry, I saw the spinning wheel happen. YouTube or StreamYard spinning wheel. But I around it.
I will work you real full days. And that will include reducing your lunch hours. And I try to give you an hour and a half because I realize you want to eat, relax, and sort of look over your notes. But all of this, folks, is going to stop, or you will be working some very fierce days. And so be prepared Saturday to go the whole day. Okay, we're in recess to 10:25.
Okay, let me pull up the next portion here, guys. Okay, they're going to take their break.
Okay, Mr. Ashton.
Here we go.
Good morning.
Morning.
I would like to address the discovery issues as to the Mr. Richard Eichenblum, who was addressed briefly yesterday. We completed his deposition yesterday afternoon. I provided the court with a copy of that, a very rough copy that we received by email. Today, I believe that counsel has received it as well. Upon review of the case of McDuffie versus State, found at 970 Southern 2nd 312 at the court's suggestion. At this point, Your Honor, we believe that a discovery violation clearly has occurred. We do, however, believe that exclusion of the witness outright is not necessary, and we would not be requesting that the witness be prohibited from testifying. We don't believe that that would be in the best interest of the defendant or.
Oh my God, is he going to ask though that they can't get? So I didn't realize again it was such a big deal that they can't give a certain opinion. If so, but now that we know that, right? It's never been done at this point in 2011. It had never been done before in Florida. So if he's going to ask for that, that's a big deal.
In the future of this case, we would, however, request that sanctions be imposed in the following way. The court has already addressed that it will, in all likelihood, address contempt issues at the close of the trial, and we would suggest that this is an appropriate matter to be included within that. We have, in the deposition, we have been able to overcome procedural prejudice in most aspects of his testimony, and I believe that I will be able to cross-examine him effectively. The only area that I cannot is one particular opinion of the witness. The witness proposes to provide an opinion which is based on the scientific principle that DNA is recoverable from decomposition fluid. This is discussed in the witness's deposition starting at page 51, going through page 62. This is an issue which, had it been properly provided, would have been the subject of a pretrial Fry hearing. The witness in his own deposition acknowledges that that scientific principle is not based upon any peer-reviewed research. It is not based upon any research at all. He would accept that principle based simply on some anecdotal experience of his own. Obviously, at this point, the the state is, because of the late discovery, and I will comment that the deposition also reflects that the opinions that this expert has formulated were formulated on Saturday, that he was never informed of the court's order about preparing a report containing all the opinions, and that he basically indicated in the deposition that he flew over here on Wednesday and didn't formulate.
This, I think, is talking about Dr. Eichlin-Bloom or whatever, not Dr. Rodriguez.
The opinions till
Or Mr.
lunch.
I don't know if he's a doctor or not, but the other guy. Because remember how there was like more than one witness. So I think that, because I missed him. I didn't catch if he said, I was thinking maybe I'll back it up. Let me just see, and then I'll come back to where we were just to see just to clarify who he's talking about here, since there's more than one. Because I didn't hear him mention a name, but let's see.
This case thing really has occurred. We do, however, believe that exclusion of the witness outright is not necessary, and we would not be violation.
See?
At 970 Southern Second by email yesterday. We completed his deposition yesterday.
It is Dr. Eichlin-Bloom. Okay, just wanted to make sure. So it is Dr. Eichlin-Bloom, not Dr. or Rodriguez. So that's who he's talking about. Okay.
Witness in his own deposition acknowledges that that scientific principle is not based upon any peer-reviewed research. It is not based upon any research at all. He would accept that principle based simply on some anecdotal experience of his own. Obviously, at this point, the state is, because of the late discovery, and I will comment that the deposition also reflects that the opinions that this expert has formulated were formulated on Saturday, that he was never informed of the court's order about preparing a report containing all the opinions, and that he basically indicated in the deposition that he flew over here on Wednesday and didn't formulate the opinions till lunch on Saturday. So what we would request, number one, is that that portion of the witness's testimony in which he would give opinions about the lack of DNA results from the carpet stain be excluded because of the procedural prejudice that the state is deprived of the opportunity to have a full and fair fry hearing. There is substantial indication in the deposition that the information would not survive a fry hearing, that the proponent, being the defendant, could not establish the general acceptance of that principle. And under the, I think the most similar holding is actually the Cybers case, which the defense has argued at length in fry hearings at 841 Southern 2nd 532, which basically, again, as the court is well aware, stood for the proposition that if a scientific principle is based in Cybers on the ability to obtain a certain chemical from a embalmed body was not scientifically accepted, then the opinion could not be offered. And again, obviously we can't have a full fry hearing, we don't have time, but I would request that that specific opinion be excluded as a sanction of discovery. Again,
that's a big deal.
Remind the court, I'm sure the court remembers, the defense has already had one witness testify about this issue. Ms. Subert from the FBI was allowed to testify about the effects of decomposition on various fluids and whether you might or might not be able to get DNA. So they have offered that testimony already. So I would object to this new expert giving an opinion based on a non-accepted scientific principle. Aside from that, we will be able to address in cross-examination the remainder of his testimony. We would request, though, an appropriate instruction to the court at the time the witness testifies. I've handwritten a suggestion, which I'll read into the record, and the court wants to have it. If you can read my writing, I'll hand it to you. Which would say, in essence, all reports of experts were required to be provided well before the beginning of this trial. The report of Richard Eichlin-Bloom was not provided to the state until Sunday, June 9th. I'm sorry. Until Sunday, June 19th, 2011. You may consider this fact in judging the credibility of the witness's testimony and in determining what weight it should be given in your deliberations. We feel that that is a fair, balanced approach to the discovery violation, and the issue of contempt would be left for another day. Thank you.
What says the defense?
Oh boy. A lot to say, I bet. Oh man.
Good morning, sir.
Good morning.
Oh, this is another day, actually.
Filed a response with the court on December 15th of 2010, where Mr. Eichlin-Bloom where the court had asked that I explain what he may be called to testify. And I listed his CV, Mr. Eichlin-Bloom's CV, field of expertise as being DNA, crime scene analysis, and trace recovery. on sentence 3, I informed the court and the prosecution that if Mr. Eichenboom were called to testify, he would testify in the areas of DNA, crime scene analysis, and trace recovery. Sentence 4, he's reviewed all reports and photographs taken at the recovery site and personally inspected many of these items, and that was during the evidence inspection. Number 5,
Actually, it still should be.
if Mr. Eichenboom were called to testify,
My days correct here.
the substantive facts that he would be expected to testify would be to rebut any false claims raised by the state's forensic experts dealing with DNA, crime scene analysis, or trace recovery. Until that occurs, it is difficult to give a complete summary of his opinions and the grounds for those opinions. I raise that because this is a very complex case, especially forensically. What I would like Mr. Eichenboom to testify to would be the issues raised about degradation of DNA. And I think this notice should be sufficient to put the state on notice that that's an issue that he will be testifying to. The opinions, this is completely separate than the issue we had with Dr. Rodriguez, and I'd ask that the court consider it differently, and I submit this for your honor's consideration.
Okay, that answers my. So I mentioned this earlier. I was like, it sounds like these are remember when I was like, oh, is this the lightning striking twice thing, or is this something that's different? Because in my opinion, it seemed like it was different. The issues were different between those two witnesses. So he just stated that. So good.
As these issues came up, and we knew that we wanted to, and when your honor gave me the example of his own personal experiences, I wanted to take that benefit, the benefit of that knowledge, and apply it in this case. I'm sure, as Mr. Ashton had mentioned, these opinions were formulated on that Saturday because these were issues that I asked him at that time. I knew we were going to take depositions, and I thought of taking full advantage of the fact that we were going to take depositions and perhaps be able to expand issues that he may be called to testify to. It's not to create any gotcha moments or anything like that. So what I would suggest to resolve this entire situation as it relates to Mr. Eichenboom would be to call Mr. Eichenboom to testify solely to those issues of DNA having to deal with degradation. While I would love to argue about the whole point of exclusion that Mr. Ashton had brought up, the issue about the being able to collect samples from decomposition fluid, Ms. Subert testified to that, and no objection was raised by the state, and they never asked for a Fry hearing then. But yet, as Mr. Eichenboom testifies, in order to try and inflame the court into thinking that sanctions are warranted here, he creates this ruse of an issue saying that we need a Fry hearing and we've got all these problems and all these issues, when the fact of the matter is it's not so. So in efforts to move things along, I would propose to the court, and I don't know if this is acceptable to Mr. Ashton, but he certainly has had plenty of notice of which, and that is to solely limit Dr. Eichenboom's testimony as to explaining DNA, specifically low copy number DNA, which Ms. Subert, unfortunately, the FBI doesn't do that type of DNA, and this witness is uniquely qualified for that,
He's agreeing to have it
which
be
of course the
limited.
state knows, and explain issues of degradation. Generally speaking, I can give him hypotheticals as it relates to some of the issues in this case, and then we can move on with this trial. I know Mr. Mason will address some other issues dealing with the other witness, but I just kind of wanted to propose that to the court and see if we can.
No, I have a thought. So it seems like, because when they first brought this dude up initially, it seems like that was the point, right? He was going to testify to the degradation of DNA, and that was what he was going to do. I have to wonder, because I was like, just a second ago, I was like, that's interesting, because he's going to say, yeah, that's fine, we'll limit some of his testimony. And I was like, that seems weird. I'm surprised they would say that, especially when it was made such a big deal about that happening. Now I have to wonder if this was smart on his, well, of course it was smart, right? It's Mr. Baez. But I'm thinking that the whole point of depositions, right, is that you learn more than you, like, it's expected that you're going to hear things that wouldn't come out of trial. Like, the point is that you're going to get everything they could testify to, and then maybe even then some. Like, it's really have them expound on things. You can ask whatever questions. There's there's fewer limitations, and that's the point, is to learn as much as you can, right? I have to wonder if I have to wonder if there was that was a smart move on his part, which was to wait to make a suggestion for how to deal with this witness until after this witness had a deposition, because this is the thing, right? It sounds like he's making a compromise by saying he'll only testify to this one thing. And I was like, I'm really surprised because it seems like that's such a big deal. But I'm having to wonder if that was the only thing they ever wanted him for in the first place, right? But then they have the deposition, and then naturally he's going to say other things because that's what happens in a deposition. And then Mr. Ashton's like, look at all these different things. And then he's like, you know what? We'll compromise. We'll be good and we'll compromise. And we'll say he can only testify to this one specific opinion. But maybe that's all they ever wanted to begin with, if that makes sense. I bet that's what's going on here.
Resolve this issue and just move forward.
Thank you.
Quick response, Your Honor?
Yes.
Just very briefly, just to point out that the state did not offer any DNA evidence in this case. The DNA evidence was offered by the defense. So the defense is, in a sense, rebutting their own witness in that sense. The other is, I'm not sure I understand counsel's proposal. If his proposal is that the witness will not give an opinion about the ability to get DNA from decomp fluid, then that's acceptable to me. As long as he's not going to make any opinions about the carpet sample, then I don't have a problem. That was the only area where I felt that there was procedural prejudice. So if that's counsel's intention, then that resolves that issue. I do not believe, however, that the instruction, I think, would still be necessary. And I believe the other proceedings later in the trial would also still be necessary. But as far as the witness goes, if that's what he means, that's fine.
Let me ask both sides to address this. At some point, the court granted the defense's motion to have certain items of evidence at taxpayers' expense tested for DNA.
Oh boy.
And it was sent somewhere, I believe, up north, correct?
Yes, sir. National Medical Services Laboratory in, I think, New Hampshire.
Okay.
New Hampshire.
Pennsylvania, excuse me.
And what items were tested?
I believe that the shorts and the bag were tested. I don't believe that the tape, I'm sure, was not tested, but I'll refer to counsel if anything more than that. I think it was just the victim's shorts she was wearing and the bag that she was found in. And that was it, as far as I know.
What happened to the tape and what happened to the carpet samples?
The defense never requested that those be tested, to my knowledge, as I recall the motions filed.
Okay. And he's proposing to testify about the possibility of DNA on duct tape.
I see where he's going with this.
And he wants to testify about carpet and the ability to test carpet for decomp fluid to extract DNA from that.
That is correct. According to the deposition, the witness was not aware of which items were requested for.
Wait, hold on. The DNA, the duct tape, hold on. I need to hear this again because what the DNA was, the duct tape was tested. I'm confused. Is this a different type of DNA testing maybe they're talking about? Because the duct tape was tested for DNA and because that's where the only DNA found was from the FBI analyst.
What happened to the tape and what happened to the carpet samples?
The defense never requested that those be tested, to my knowledge.
Oh, different.
As I recall the motions
That's
filed.
why. It's the other tape. Okay.
Okay. And he's proposing to testify about the possibility of DNA on duct tape.
Yes, sir.
And he wants to testify about carpet and the ability to test carpet for decomp fluid to extract DNA from that.
That is correct. According to the deposition, the witness was not aware of which items were requested for DNA testing or what the results were. He apparently was never informed of which items were being requested or what the results were, according to his deposition.
So in other words, he was not aware that those items could have been tested for DNA and they were not.
I believe he would say in his deposition that he believes they could have been tested, but was unaware that they were not.
Okay.
May I address those?
Yes, sir.
With the court? We're talking about completely different types of DNA testing.
That every
testing,
time I ask a question, he answers it. There it is. That's what I was wondering. Okay.
that he does is low copy number DNA type testing. They utilize a special kit called a mini filer that allows you to get DNA from
Oh,
very, very, very minute amounts. That type of testing
And that-
is unique.
And that explains it, right? That explains why. Okay,
He
now
requested that they be allowed to test items, and that, of course, was objected to by the state, and the state granted or sustained their objection and denied our opportunity to have.
let's make sure this is clear. The state did not want those other items go for additional further DNA testing. The state did not want things tested.
Him test these items
Yes.
due to a very specialized subfield of DNA that he is one of the pioneers of. In the alternative, we were granted the ability to test certain items by an ASCLD certified lab. We asked specifically for a different type of DNA for those items because we thought it would probably be the most likely scenario for us to be able to accomplish getting something of benefit to the defense. And that type of DNA was not low copy number DNA, it was YSTR DNA.
So are you saying that there's no certified lab in the continental boundaries of the United States that does low copy DNA testing?
My understanding is that the only crime lab currently doing low copy number DNA is the New York City Crime Lab. And I am not aware of any other ASCLD certified labs that do low copy number DNA in the United States. In Europe, it's quite prevalent. Of course, DNA was actually discovered in Europe and developed in Europe, and they're, by many people's estimations, a little bit more advanced than we are here in the United States.
Interesting.
As far as low copy number DNA is concerned.
And has low copy DNA been fry approved yet?
It has. Well, let me rephrase that. It has been used in cases out throughout the United States, but whether it's been fry tested here in Florida, I can't say.
According to the witness's deposition, the procedure he uses is a standard procedure developed in other laboratories. He did not indicate that he does any. He explained that low copy number is simply additional replicating runs of a traditional PCR method. Instead of running it 24 times, you run it 30 times. He did not indicate in his deposition that this is a procedure which is unique to his laboratory. He did not indicate in his deposition that this is not done in the United States. And I'm not aware of what counsel is referencing about the inability of United States laboratories to perform these DNA tests. This is the first that I've heard of that. So for what it's worth.
That's absolutely not true. There's a special kit called the mini filer. I'm certain Mr. Ashton's aware of it. It's not just doing extra runs in the PCR process. It is a specially designed kit.
Oh dear.
And it is, how prevalent it is in the United States, it's still up and coming. From my understanding and my studies of DNA, I can represent that to you. And I can say this much. I've studied quite a bit in this area, and Mr. Eichenboom is well known throughout the DNA community as being a pioneer in this area. Whether he does something a little bit different, other than the amplification process and using these specialized kits, and more importantly, the type of trace recovery that they utilize. And the witness is here, he can testify as to the uniqueness of what it is that he does that's different, but we would certainly object to any, especially since we are conceding and willing to stick to areas that are and should have been very well known to the state, to anticipate Mr. Eichenboom's testimony, for which they did not take his deposition up until recently. We would object to any specialized instruction trying to punish the defense in any way other than what we've just discussed.
Okay, anything else?
Oh my God.
Okay. The court hearing arguments of both the state and the defense will grant the state's request for the instruction.
Oh no.
And at this time would prohibit the testimony concerning the possibility of testing by DNA analysis of the decomposition fluid in the trunk. Now, what the court would do out of abundance of caution, if since it looks like we're going to be doing this for the next 2 weeks, if you want to schedule a Fry hearing, given the state at least 1 week's notice, I will consider doing that to see whether or not it would be admissible. But for the time being, it is not going to be permitted as a sanction for not disclosing it. But I will not permanently shut the door, but give you an opportunity upon proper notice. I will permit anyone that has an expert to testify by video conferencing if you want to conduct a Fry hearing.
That's the light at the end of the tunnel. So hopefully that witness isn't already there in Florida, because, you know, they have to bring these witnesses in from all over the place. So that is good. He's saying, if you want to conduct a Fry hearing, wow, this trial's crazy. There's a lot going on. Like, they were already 6 days a week. Now they're 6 days a week, but they're going to be doing 8:30 to 5:30, 6 days a week. But at 5:30 on most days, recently at least, right? They're staying after to take depositions. And now we're talking about a Fry, like that. This is a lot, but that's good for the defense, right? That he can testify by video conference. And surprising too, for 2011, that's really, you know, I'm glad he's allowing that. And that's great. That's, you know, and it's crazy too, right? Because like, see, now this is more common, and that, you know, from everything I understand happened with the courts changed a lot because of COVID, right? It used to be that it was a big deal to do anything like that. But this is 2011. That's why I'm like pleasantly surprised.
Okay. Yeah. Hope I can read your writing.
Your Honor, we would object to the state's. We hadn't been given a copy of the proposed instruction. I just looked at it now.
You have an alternative instruction?
Yeah, to give an alternative.
We didn't know they were going to be requesting one. We can prepare one.
Yeah, there you go.
Who's going to be your first witness this morning?
We can, to delay the issue, call Dr. Jane Bach, and in the meantime, we can prepare. Hold on, I'm getting lit. I believe we can call other witnesses to, in the meantime, while we prepare instruction.
Okay, prepare one. Have someone kind of give it to the court deputy, give to me, and then between the two of them, I will fashion something on my own.
Yes, sir.
Okay. Anything else, folks? All right, let's return to jury.
I already know who's coming up next. It's a witness we've seen many, many times before. And it's a lady. I'll give you all a hint. It's a lady. I wish I'd been keeping track. If I had known, I would have been keeping track this entire trial, because it's really, there could be a contest, right, for the witness who testifies the most times. And I mean, some of these witnesses have testified. I mean, this witness that's about to testify right now, I mean, 8, 9, 10 times, maybe more. At this point, I've never in a trial seen this. Like, it's usually it's unusual for someone to come twice, right? But we're about to see somebody we know very well. Good guess, not Cindy though. This is someone from law enforcement. You want to take another guess before I hit play? But don't worry, we do see Cindy. Cindy does come again, at least another time, if not more. So we will see Cindy again. But this is someone from law enforcement. And the names might be a little bit harder to remember, though. Your brain's, that's okay. Jennifer Welch. I don't know if you remember, but she's testified a bazillion times. Jennifer Welch. All right, here we go. There she is.
Jennifer Welch, W-E-L-C-H.
You may proceed.
Thank you. Ms. Welch, I believe you've already established that you are a CSI Orange County crime scene investigator. Is that correct?
Yes, that's correct.
Okay. All right. And did you author a report dated February the 1st, 2009, and the bait stamp would be 3433?
For anyone who's like, who's that lady talking? That's Miss Sims. We have not heard from her much from the defense. She's questioned like maybe 2 witnesses, maybe 3, maybe 3. This is her first witness for the defense's case in chief, but the other witnesses she's done was cross-examining during the state's case in chief. But that's who that is, Miss Sims.
That indicates the end of day observations with regard to clearing of the scene December the 12th through the 14th.
Yes.
Okay. All right. Can you explain, or if you need to refer to your notes, that's fine, what your observations were?
Yes.
She may as well just live in this courtroom.
Yes. On that day, December 14th, 2008, at the end of the day, I made observations that during the period of December 12th through December 14th, with December 12th being the first day of searching and clearing the scene, that the areas had been cleared of leaf litter and vegetation from approximately 0 to 4 inches. And around the trees and the tree roots where the crevices were, it had been cleared approximately 0 to 10 inches.
All right. And do you have an end of scene, a day scene observation, Bates stamped 3430?
I will say, like, honestly, she's probably, if you look at all the days of this trial, I would say she's probably testified more days than not in this trial. And I was just thinking, like, how is she even doing her job? Like, the amount of time, like, maybe her testimony isn't always long, but just the amount that she's had to be available for this trial. I wonder if that's like literally all she's doing, because I don't know how she would be out, you know, doing CSI stuff, right? I mean, anyway, it's just interesting.
33.
I don't have,
it says page 22 on the bottom.
Thank you.
There's handwritten Bates stamps, so ours may be different.
Yes, page 22 of my report is what I just
Okay.
testified
All right.
about.
And did you read the last sentence?
The last sentence under my end of day observations?
Yeah.
Yes, that's what I had mentioned about around the tree and tree roots being cleared approximately 0 to 10 inches as determined with the tape measure.
Okay. Now, I believe you previously testified that you took photographs when you arrived at the scene. Is that correct?
Yes, that's correct.
Okay. And when you took photographs in and around the area of the scene in which the remains were moved, did you alter the remains or take anything off the remains that was touching the remains or the vegetation around it, other than to maybe lift something that was hanging over it?
The vegetation around the area was cleared to the point of the vines being cut and tied back, but I do not recall removing any vegetation from actually on top of the skull or on top of any other evidence, again, other than just clearing away vines that was obstructing the view.
All right, and I just need to confirm in terms of the photographs that you took, they would be CSI call numbers. Is that correct? Is that how you determine them?
The photographs are entered into our database under call ID numbers. That's correct.
All right. And are you familiar with the call ID number 1932?
So, you guys have any ideas like who we might be hearing from next from the defense, given what these questions, right? Like, so what the reason they're calling her, right, is to lay the foundation, because they're asking about these photographs, and they're asking about specific things in these photographs, and these are questions that have not been asked yet in this trial about these photographs of the crime scene. So she's mentioning the plants, the foliage, blah blah. So, any thoughts, guys, on what expert we might hear from next? Not like a name, but like the job title, like their field of expertise.
I do not have a record of 1932 as a call ID number.
All right. Did you take photographs of the scene after the vegetation had been cleared?
Yes, I did.
Okay. All right. May I have permission to publish this just to the witness?
Which exhibit is it?
Oh,
this has not been entered in yet as an exhibit.
Interesting.
Okay.
Cool.
You may publish it to the witness.
New exhibit.
Request that it be marked for identification so that there is a permanent record of what's being shown.
What would that number be?
Hand it to the clerk. Speak up a little louder so
If you're referencing Roy Kronk, he has not testified yet, and I'm not looking ahead, so I don't know who calls him. I mean, it's got to be. I would imagine it's got to be the defense, right? But it still just shocks me that the state didn't call him because he's who found the body. So yeah, you've not missed him. Maybe he'll be their last witness.
It appears to be, yes.
I asked her if that appeared to be a photograph
Okay.
that represented the
For
scene after
Ashton.
vegetation had been cleared.
Thank you.
And I'm not really sure how to work this, so.
The Elmo?
Can you?
It's upside down. Flip it over again.
There we go.
Pull it down, son.
Oh, I see. Okay, great.
He's never used the Elmo. Look at their cute Elmo. I love their Elmo.
Publish the witness note.
I love that their Elmo. It's just so funny, right? Because the Elmos are already so old school. Like this one's a new school one compared to others. But like the fact that that's what they use in court, like I love it. Please don't ever change. But like in the world of technology, those are from like the dinosaur ages, like relatively speaking. And the fact that she doesn't even know how to work that is amazing, right? It's like she's used to like a chisel, like and stone or something. Oh my God. Like, look at this, the struggle with the Elmo.
Flip it over again.
I mean, really, I think those have been around since like, I don't know, the 50s or something. Anyone want to look it up? Like, when did Elmos first come around? Like, I mean, they've been around a long ass time.
There we go.
Pull it down, son.
Oh, I see. Okay, great.
Oh my God, I love this so much. I just love it so much. And I love that this Elmo has a little Betty Bye, as I call it. It's like, it's got its little, because see this, what I imagine is that this whole setup is great because I guess they can pull this down when they're done and then fold the Elmo over and then the Elmo goes into its little bed and goes and has a good night's sleep. I just think the Elmos are so cute.
Publish the witness note.
You're on permission to publish to the witness?
You offered any evidence?
Yes, sir.
Any objections from the state?
No, sir.
It will be received in evidence as defense exhibit
Flashes on.
number.
They'll let us know when they were invented.
Okay, you may publish it to the jury.
Thank you.
I will say she has come in clutch a couple times. One of the things that I just know her for, like she's come in clutch with the case law. Like obviously she doesn't do a lot of the witnesses typically, but there's been a couple times where there's been some important issues being discussed outside the presence of the jury, and she's come over and handed some case law over to Mr. Baez. He says, Ms. Sims just found this case law. And there was a couple times where it was like really important case law and helped them out big time. So, I'm wondering if maybe she's just not, this isn't, some attorneys, they do a lot more with the research, right? And I'm wondering if that's maybe more of something she does because of, she's doesn't seem as comfortable with admitting things into evidence, and obviously never used the Elmo before, so nothing wrong
And
with it.
can you identify, please, what that photo?
Okay, it's about a 4-second delay.
That's right, I forgot. Ms. Welch, can you identify that photograph, please, and advise the ladies and gentlemen of the jury what that represents?
So Elmo
It appears to be the scene after vegetation had been cleared.
Okay.
Elmo is the brand.
And is that an accurate depiction, in your opinion, of the scene, the area in which the remains were found after the vegetation had been removed?
From what I recall, yes.
That's vegetation.
Permission to unpublish, Your Honor?
You may.
Can you tell me, please, in your report, and since our bait stamp pages appear to be different, if you could look on page 5 of your report, and can you tell me, please, whether or not there's a reference to a log or a tree near the remains and what happened to that log or tree?
This log has been brought up before, but we didn't know why it mattered.
Yes. The log was located directly near the skull, which was observed on December 11th, 2008. During the process of clearing and moving vegetation, the log was moved by Chief Medical Legal Investigator Stephen Hansen and my supervisor Susan Mears on scene.
That's going to come up, the log.
I have a photograph that I would like to, with the court's permission, publish to the witness for identification.
Oh my God, Flash, you're the best. The Elmo projector came out in 1927 in Japan. So there you go. My guess was, I was like, maybe it's been around since the 50s. Thank you so much, because that's even better. 1927. First of all, that's incredible. But that just, so here we are in 2011, and she does not know how to work this. That is amazing. I'm so glad to know that tidbit of information. People who love watching trials will be delighted with that little piece of trivia, if you will, because that is so cute. Go Elmo, go Elmo. And this is like the most fancy one I've ever seen that they have here in this courtroom. And it looks like she's going to have to try to use it again here with another picture.
And it's 1840-196206.
Okay, has the clerk marked it?
Yes, sir.
Okay, let the clerk mark it.
Thank you. Do you recognize that photograph?
Yes.
Okay. And is that photograph an accurate and true depiction of the scene in which the remains were found on December 11th, 2008?
Yes.
Okay. Your Honor, may I have permission to publish this to the jury?
Any objections? Did the
Process this photo was taken.
I'll be glad to clarify that. Can you tell us approximately when this photograph was taken?
I cannot give you an approximate time, but I can tell you that from looking at this photo, this appears to be a photo that I had taken after vegetation had been moved out of the way. In other words, to aid in no longer obstructing the view.
When you say,
go ahead.
when you say after vegetation had been moved away, that's hanging vegetation, not anything that's laying on.
Okay, the dangly bits.
The items themselves. In other words, no leaves were removed or twines that were actually touching the items. Is that correct?
Yes, from what I recall, this photo is just vegetation being moved out of the way to no longer obstruct the view. I do not recall removing vegetation off of the items.
Okay. Your Honor, may I have permission to publish to the jury?
Okay, any objections to coming in evidence?
Any guesses, guys, on who the next expert
Madam Clerk,
witness was?
be admitted into evidence as defense exhibit numbered. Okay, you may publish 28.
I can't tell if it's up. Thank you. Your Honor, may I unpublish?
To the jury, have you seen it? Okay, you may unpublish.
Thank you. That's all I have of this witness, Your Honor.
Cross-examination?
You're going to cross her on that? I don't even understand. Like, literally, it's just getting those pictures in the other one.
Can you tell us what portion of the scene, this is, maybe orienting us by some object that was found? I'll zoom out a little bit so we can see the whole thing, if that helps you.
While it does appear to be a photograph of the scene, without going through my CD of photos in the sequence of photos, I can't tell you precisely where in the scene this is located.
So you couldn't like point to a spot and say, well, this is where the skull was, this is where you don't know from this photograph.
That's correct.
No further questions, Judge.
Any redirect?
Just very briefly.
Okay.
Ms. Welch, how did you identify the grouping of photographs? Did they have call numbers? How did you do that?
I guess I don't understand the question. I'm sorry.
Okay, you took photographs, and there was a series of photographs. And I understand it have CSI call numbers like 1832, which contains a number of photographs, 1840, 1842. What was your identification system for those photographs?
What I did was I took the photographs out on scene, and then they were uploaded into our digital crime scene system. When they are uploaded into that system, the system gives it a call ID number. That way we can go back into the system, or a detective.
She's never given this answer before. What do you guys think?
If needed, can go into the system, put in that call ID number, and pull up the photos that are under that call ID number. So it is not a number that I created. It's a number that the system created.
Okay, and do you have those numbers here today?
Yes, I have the numbers.
Okay. And just for clarification, if I read them to you, would you be able to verify that they are in fact the CSI call numbers for the photographs that were taken on December 11th, 2008?
I would be able to tell the number of photographs without actually going through my report and looking at the corresponding number of photographs to the call ID. I wouldn't be able to tell you exactly what day the call ID matched up with.
But you would be able to determine that these were photographs that were taken at some point in time, December 11th through the 14th, approximately?
December 11th through the end of the investigation, I would, yes.
All right. And do you have those call numbers readily available?
Yes, I do.
Okay. Would one be 1838?
I do not have a call ID number of 1838.
Okay. What are the call numbers that you have?
I have call ID numbers 1840, 1842, 1845, 1849, 1893, 1903, 1913, 1919, 1923, 1934, and 2088.
Whoa, that one's a lot.
All right. Thank you, Your Honor. That's all I have.
Okay, any additional questions? No, sir. May Ms. Welch be excused? Okay.
Yes, sir. Again.
You may be excused, subject to recall. Thank you, Ms. Welch.
Thank you.
Okay, so I think, let me take a look. I think the next witness we will be saving for next time. Let me just see here. Yeah, because that is going to be that's going to be a long witness. Okay, so you can see the name, but it doesn't say what she's doing, Jane Buck. So that's going to be the next expert witness. And I'll just go ahead and let you guys know. So it's a forensic botanist, which I've never seen in a trial before. But it came up in the state's case in chief, right? There were some questions that came up with one of the forensic anthropologists, right? And or maybe it was with Dr. Haskell with the bugs, but the defense was asking questions about the plants or whatever that was coming up. And it was it came up that the state never used a forensic botanist, right? That they did not utilize a forensic botanist to examine the plants. And as soon as that came up, I was like, I bet the defense is going to bring in a forensic botanist. Sure enough, that's who we have next. And if I had to guess, I would imagine that there's going to be some overlap here. Well, not overlap, but that when we heard about the bugs, right? The plant life came up, and I feel like the same thing's going to happen here, where we might get a little bit of context too from the bugs. But it'll be really interesting to see what they testify to, because a forensic botanist, that is a very, very it's a very unique field and something we don't see. So at least not very often, and I can't recall ever seeing it. So that will be exciting, and that will be the next witness. Flash is wondering what court trials looked like in 1927. I know. Well, I mean, I think that in Massachusetts, there's not been a whole lot changed from what we know. That courthouse only just got Wi-Fi the week of the Karen Reed trial. But yeah, I mean, I don't know. I mean, I'm just thinking about how the thing that would be the biggest difference, I would imagine, is that there's the case law, right? And also things like statutes, rules have changed, laws have changed, but also the case law has changed. So things would be different, very different. But I think that other than that, a lot of stuff was probably pretty similar, because again, they're so far behind in technology and they're so reluctant to change that I think that I think that other things have probably changed a lot more over that period of time. I would think. A time machine, I know. But that's it for this one, guys. I think tomorrow we're going to be doing Shannon Gardner. And we're going to go through part 2 of the death penalty motions. I did check just today, and there's not been anything else new filed in that case, apart from there was one thing filed. It was it was the judge ruling on denying a motion to get the grand jury transcript for Detective Johns. But it's one page, and there was nothing noteworthy in there. But other than that, there's not been anything else come out in terms of court filings. But we will still be making our way through those death penalty motions. So that'll be tomorrow. And But anyway, yeah, that's it for this one. So we will be picking back up with continuing on with day 23. It'll be defense witness number 12. But y'all are awesome. And that's right. I know. I heard that. Thank you though. I heard somebody mention that hearing was like nothing happened. So yeah. But thanks everyone for being here. If you're interested in checking out, Flash did put a link in the Discord for where you can watch the streams there. And then also Candace put a link in the Discord for anyone who's interested in, sorry, I nailed my spit. Interested in supporting the charities who are helping out with the fires in Los Angeles. So those are in the Discord as well. So, but thanks everyone for being here. Love y'all. And I will see you guys next time.